I will not hear anything. All mentioning list due to my court of matter. Only unlisted. If any urgent, I will take.
My lord, I have one urgency with regard to leave, my lord. My lord, I am mentioning from virtual mode, my lord. I pray for urgent leave, my lord.
Give whatever the urgency, give the urgency mentioning list.
My lord, may I please permit to mention?
Mention the urgency, give the urgency list to my court officer. That's all. Whatever it may be, give the mentioning. That's why I mentioned. Okay, give the mentioning list, no problem.
Lordship, interim is expiring tomorrow.
Give the mentioning list.
Interim order.
Hey,
Mentioning slip.
ओटा कल के अर्जेंट एंट्री मॉडल उसको अलग करो
हेमंत
जरा सुन लिया करो
₹12176.
yes take and call the list.
My lord, may I please permit to mention one leave matter, my lord? I have one urgency leave matter, my lord.
For release lordship.
My lord, unlisted.
Please permit to mention release matter.
Urgently, my lord, this.
What is the urgency? Where is the unlisted motion?
What
is the urgency?
This is related to defreezing of the business account which has been frozen, my lord. My lord,
there are several accounts of the business account frozen. No, bank is not coming. If I are listed also, bank will not come. The court will not be in a position to you serve the notice. File it, then I will see to the notice.
My lord, my name has been given in the CFR, my lord. My job is being hampered, my lord. If it is not heard by tomorrow, my lord.
Lordship, item number 32 of today, Lordship. If Lordship.
What is the urgency?
Lordship, tomorrow is the date. This is the last date. I will be ousted from my place of operation. Your Lordship has given leave to put this matter in today's list. If Lordship kindly, if Lordship can't reach item number 32, I will be highly prejudiced, Lordship.
What is the matter? I am asking. You are only telling the facts at 2 p.m.
Lordship, tomorrow is the last date. I will be ousted from
the last date.
From my place of business, Lordship,
when issued a notice for your eviction?
Cancellation order has been issued by the university.
When the cancellation order was issued?
Lordship, 18th May 2026.
So what you have done since 18 May?
The last date is tomorrow, Lordship.
When you file the writ application?
On 22nd, Lordship.
So 18th May and 22nd June you file the writ application.
My lord, kindly.
Eviction date. And you filed and you mentioning the urgency.
My Lordship has granted the leave, my lord, to appear.
Granted, it is in the list. If it is called, it is called.
I'm the government school teacher having salary account, but one account I have also another account which is loan account.
File it. There's no urgency. Yes.
They have seized my book at the account under the RBI guidelines. But the RBI guidelines
bring the issued notice, bring the other side, I will take. Otherwise, the bank is not appearing in any of the freezing matter. The court can
only facilitate my salary account.
Release, Lordship. Give.
Lord, may I be permitted to mention a matter?
Milord, yes, call the list.
Milord, in this matter.
My lord, may I please permit it to mention a matter? Tomorrow is the last day. My lord, in my matter, my lord.
Two, Milord. Milord, leave be granted. Milord, we want to intervene in the Friday matter.
Opposing this, Milord.
The adjudicating authority being given non-judice.
Milord, there is no urgency. Milord, kindly appreciate. Oh, sorry.
Yes, who is the number one?
Hi, Milord.
Who is appearing in item number 1? Where I am dismissing the writ. Where is the forensic audit report? In writ petition, you are not your seniors have argued the matter. Forensic report is the same. Where is the forensic audit report? I am dismissing herein now. And you argued that all the forensic reports are similar.
Counsel will appearing online.
You are misleading the court before this court. You have taken the 4 dates. All the forensic report are the same. When the court has gone through all the forensic report are different. This court, though the matter was heard, but and the case has fixed for CAV, but at the time of going through the record, this court find that the petition has not disclosed the forensic audit report. Accordingly, the petition is dismissed. Next.
Milord, I appear for
item number 2.
I appear for the petitioner, Milord. Milord, this is that tender matter, Milord, wherein we were
Yes, Mr. Chaudhary, what you are mentioning? This matter only.
Next matter, my lord.
I will take. Yes.
So, my lord, we were the highest successful bidders.
Ah.
Now, post.
Where is
my
the
lord, my
affidavit of service?
senior kindly allow.
Where is the affidavit of service? If it not served, not today.
All of them, sir.
I have allow you
My lord,
to.
all of them have been served.
Where is the affidavit of service? Where is the affidavit of service?
My lord, the affidavit of
If it is a failed to produce the affidavit of service, under such this court is not empowered to take the matter notice and file the affidavit of service. Yes, next.
my lord, the affidavit of service could not be prepared, but my lord, we have emails of all the service, my lord.
Okay, no problem.
My lord,
Where is the affidavit of service? There is no service.
my lord, we have served lordship and they are appearing as well, I'm told.
Yes, next.
My lord, will kindly consider lordship, the auction is going to take place.
I have allowed the mentioning to service of the notice. Where is the affidavit of service?
Lordship, but we can show that we served.
Court had said after 1.5 hours, but you are not able to prepare the affidavit of service.
My lord, we
Where
have.
is the affidavit of service? Yes, call the third. Yes, who is in the three?
To intervene, my lord.
Mr. Mitra, specifically I told you, serve the copy. So where is the affidavit of service? The court will go and affirm the affidavit. Then
Letter is there serving.
let this face the problem. Yes.
Leave to file, my lord, with short process.
And I am opposing this one.
Oh, yes. Well, this is that matter where
There is no, it's my application. But here I have come before your lordship, challenging the authority of the adjudicating authority under the PMLA Act. It's not properly constituted.
well, can it be tomorrow?
Let me hear the petitioner. Yes.
Well, can it be tomorrow?
No, Mr. Mitra, this practice, seniors are mentioning the court by seeing the face of the senior, allowing and specific directing to serve the notice, but your juniors are so busy, not in a position to prepare the affidavit of service, how the court will take? Juniors should learn. Only by saying that it is an urgent matter and mentioning and without the service of notice, how the court can take this urgent matter without the service of notice?
Service has been made.
Where is the affidavit?
Affidavit is not
Then
there, but
that Mr. Mitra, you are the senior.
I know that.
Can the court see? Yes, this is the service. This is the service.
I know, but I get to justify. But can it be at 2 p.m. today? We can come back with that.
Today already fixed matter.
I know that. I am very. This is something, Lordship. I also don't look into. I'm not supposed to be looking.
No,
into
that's
this.
senior should not. It is a duty of the juniors.
Well,
Duty of the juniors. But I find from this bar the juniors are only for taking time. If they are not able to prepare the affidavit of service, what they are doing in the chamber?
well, in half an hour it will be done. Well, may I try my luck after this matter?
Affirm it, we'll see to that.
Well, this is my writ petition, my lord. Where, my lord, I have challenged, my lord, 3, my lord, show cause notices along with the reasons to believe under section 8(1) of the PMLA Act. Only on the ground, the adjudicating authority has to be 3 members. And, my lord, as I told on the last occasion, this came before your lordship. Your lordship did not find favor in the submission which I am supposed to make. But subsequently, the Supreme Court has passed an order. Following that, your lordship has also, my lord, in subsequent matters, has directed, my lord, that stay. So I have come before your lordship only for that specific, my lord,
Yes,
challenge
what
at
is
this moment.
I have prepared a formal application for leave to intervene because my right.
Who are you?
My lord, I am South Point School.
No, you are the complainant.
No, my lord, I'm
You are
sorry.
the complainant.
No.
Ah.
It's my funds which my lord have been.
My lord, may
Okay.
I make a submission first here, my lord? This has been made on a repeated occasion, my lord. It can come. No. My lord, they can intervene, they can file, my lord. I'm saying because there is no urgency, I'll point it out why, my lord. 2 things, my lord. He has himself said that he is the person whose money has been taken over. That is what he's saying, my lord. But under the PMLA Act, my lord, your lordship knows better than me, my lord. It's a proceeding by the central government. Now, under section 9 of the Act, my lord, whatever proceeds, if they are found as the proceeds of crime, my lord, they go to the central government. My learned friends will have no right. That is the law. 7 except my lord, section 9 provides that they are entitled to file a suit for damages. So today, my lord, on the face of it, my lord, they were never in the proceeding. I've only challenged the procedure. They have never been there also, my lord. And the complainant is a different person, it's the director, my lord, who's filed this complaint. So, my lord, this, my lord, not the South Point director. I should be very specific.
Correct.
And my lord, I've got Mr. Banerjee on my side, so I need to be specific, the criminal matter, my lord. So, my lord, so, my lord, no, my confusion is all because of Mr. Chaudhary. So, my lord, therefore, I say, my lord, there is no urgency, my lord, kindly considers my interim prayer for today, my lord. For that, this should not be, my lord.
Okay, yes.
What I want to do is I have locus and why was I do not have the right, any right for this money. No, I show your lordship this section.
No, Mr.
Receive this money. Now, if this is my asset, which has been not attached, when the bank is not asked for its return, I'm definitely saying who has to be heard. I'll show your lordship this section.
No, that's correct. That's
This is not a proceeding.
I'll show your lordship this section.
That's correct. That's correct. But in this, how you will be affected?
Because my learned
In this, how you will be affected?
it's my. She's been found to have been first client.
Correct.
The ED has found the table
Correct.
and it says it is lying in the form of various assets which have been attached.
Correct.
Now, as my friend says, not the mechanism under this act is not this was central government. But this can be applied to one order of the special. That's the section.
Correct.
So, my learned friend said, local standards. Correct. Our person I'm entitled to look this way. So we have definitely intervene. There is no tourism on that.
Now,
Not at this stage. sir.
what is your prayer in the if you intervene also? If the court will allow you to intervene, what is
I'm seeking sufficient.
the
Lordship, I am seeking sufficient net safeguards in relation to the property which has been attached. That is what I seek. And that is the subject matter.
See, the matter is before the adjudicating authority. Authority has seized some materials or whatever the assets, whatever it is. Correct. Now the adjudicating authority has to decide whether that is the debts or whatever the property is the property of the crime or not. Correct. If it is found that if they satisfied it's a crime, then it has to be sent. A report is to be submitted. When the report is submitted, then ministry will take a decision whether it has to be prosecution is to be launched or not.
Correct.
And if you find that the seized property is your, you can make very well application before the court for release of the property, for getting the property back from the special court. Neither the adjudicating authority nor the writ court nor the ED authority will allow you to take the
He is seeking understood it, but he is seeking to challenge the order of attachment. That attachment goes. That is why
No, they have at present they are asking today. They are asking that adjudicating officer single member of the adjudicating officer could not pass an order. That is the only.
So,
Pass several orders.
the order goes. If that order goes, this entire
Goes today I am not going to pass any adjudication whether the notice is this court only see whether the single member the adjudicating authority can continue because the Supreme Court has already stated the proceeding directing
not it has made sure that the property is protected by same.
I've not asked for
this court is not going to pass any order to release the property is passing. Today only I direct the authority not to proceed with that till the disposal of the Supreme Court to decide whether the single member or
I am with your lordship, but the Supreme Court is not imposing conditions. It is given undertaking.
Correct, same condition. Same condition. Please see whatever the order I am.
No, that's all right. But I thought your lordship was saying today order is going to in relation to the property. But the order is that he has to give sufficient undertaking.
Yes.
The second thing for lordship, please consider, which is this, your lordship knows that
Yeah, what purpose? Solve the copy, let it be listed, that will be decided whether you can intervene or not.
Absolutely.
Even though
One other thing, if a lordship is considering an order, just consider one more factor, Lord. But one is this business of undertaking. Second is, please remember, Lord, an order of attachment remains for 180 days. This order will automatically lapse if there is a stay of proceedings. If there is a stay of proceedings, Lord, this attachment is going to lapse. So, Lord, one of the reasons, please record his undertaking that he is not going to claim the benefit of this stay. See the number which that attachment would honor will come to
Yes, the petition will be directed to furnish an undertaking before the court by 2 days, not to align not to alienate the subject property.
if it comes to us, it's already attached.
If
it comes to us,
There is
But the Supreme Court has put the condition, the same condition will follow. Nothing else.
attached properties, we have nothing to do with this anymore.
With regard to this, my lord, a status quo is to be provided.
Yes.
It's not that the property will be released. Second, my lord, there's a definition of proceeds of crime under 2(1)(u). It means any property derived, obtained directly, indirectly.
That adjudicating authority will decide. The court is not. If in future the Supreme Court allows or dismiss, if the court is going to decide the matter on merit, then all the things will come in.
absolutely.
Then in that case, Mr. Client, his client can also be come and argue the
Well,
matter.
that is subject to
But yes,
That's not today.
but just to digress for 30 seconds,
And they don't have right to.
just to digress for 30 seconds, actually your lordship is not fully familiar with this matter. It's to do with South. That's a Mr. Nani.
It's a whatever Mr. Potter is or not, that is also a question, Ballard, because also first. Let us see.
If you notice.
Yes, Malad. Malad has Malad konta Malad
Item number 3 page number
3 Malad, page number 231.
231.
Yes, Malad. Malad, here there are 3 petitioners. I paid 3 court fees, Malad, because these are questions of law, same questions of law, same Malad. There are 3 show cause notices, one at 231, the other is 255, and the next one is 267. These are 3 companies, Malad. 231, 255, 267.
231,
255 and 267.
255.
55, Malad.
Lord, can I see what my learned friend is referring to? Lord? This petition.
Let him first.
What is it?
And
267.
267. Item number 3.
Item number 3, Malad. I'm talking about.
why you file the single writ petition?
Malad, this is for 3 companies, Malad. Malad,
Same date notice.
Sorry, Malad.
Same notice.
No, Malad, the notice dates are different.
Then
Same day notice. Same day.
Same notice যেটা আছে, that is at page
same day notice.
79.
Yes.
279 is
Same proceeding.
Same
Under the same proceeding.
Also in item 4 and 5.
Engineering steel.
279 এ দেখো
The petitioners have challenged
আলাদা আলাদা করে
the so-called notices dated 30th May 2026 issued by the chairperson within bracket acting adjudicating authority within bracket PMLA dated 13th of May 2026. The primary ground of challenge of the so-called notice dated 13th May 2026 is that the adjudicating authority was the quorum non judice. He submits that a single member who is only acting as an adjudicating authority, even not being a judicial member, has issued the so-called notices. Let consider for the petition submit that similar issue same over. Similar is paragraph 2. 3, 4. No, yeah, others are not additional solicitor general. On the other hand, it's okay then. 2 number आएगा, then 3. Let consider for the petitioner petitioners submit that the Honorable Supreme Court has passed an order for maintaining status quo of the further proceeding before the adjudicating authority, and thus the similar order can be passed by this court in the present writ application. Now, counsel for the petition submit that the petition has moved the present writ application in an urgent basis on the ground that 27th June 2026 is the date for filing written reply to the so-called notice issued by the adjudicating authority. Full stop. Okay. The learned counsel for the yes, what is your submission?
My lord, the petitioner be directed to furnish.
Okay, that I will learned counsel for the petition submit that if this court will pass any order for status quo in terms of the order passed by the Honorable Supreme Court, the petitioner may be directed to file an undertaking before this court that they will not alienate the subject property in any manner and shall not create any third party right in such property without prior permission of this court.
And affidavit's direction. Affidavit's direction.
Full stop. The learned counsel for the Enforcement Directorate press for time to file affidavit in opposition. Mr. Bachawat, learned senior advocate appearing for the intervener, submit that he is having interest in the matter and intend to intervene in the matter, and he is a necessary party to the present proceeding. And he prayed,
I filed an application.
he prayed for.
I'm seeking leave
He seeks leave to file an application intervene in the matter to be added as a respondent, one of the respondent in the present date application. Full stop. Had the learned counsel for the respective parties produced the materials on record, this court find that the Honorable Supreme Court has already passed an order. Consider the submission made by the counsel for the respective parties, produce the materials on record, in view of the order passed by the Honorable Supreme Court, the adjudicating authority is directed to maintain status quo with regard to the further proceedings of the instant matter until further order of this court. Full stop. The petitioner is directed to furnish an undertaking before this court by 23rd by आज कितना तारीख है?
2 days.
Today कितना आज कितना है? 29. By 2nd of July 2026 to the effect that he will not alienate the subject property in any manner and shall not create any third party right in such property without prior permission of this court. Full stop. As regard the filing of the application for intervening in the matter, the intervener is given liberty to file the application after serving the copy to the learned counsel for the petitioner as well as the Enforcement Directorate. Full stop. The petitioner is at liberty, petitioner and the enforcement directors are at liberty to file affidavit in opposition to the application, if any, filed by the intervener within the period of 2 weeks. Full stop. It is also given liberty to file affidavit in opposition to the present application within the period of 2 weeks. Full stop. Reply, if any, there to be filed within a week thereafter.
And the locus is under challenge, keeps it open, my lord. That's what I'll file affidavit.
Week thereafter. Full stop. List the matter. 4 weeks. List the matter on 5th of August 2026. 2026.
But 1 day only.
6th of August 2026. Police learned counsel for the petitioner raised an objection with regard to the locus of the intervener that is kept open and will be decided at the time of hearing of the application.
Just leave is going to file with short cost title. I don't have the full cost title.
No, file intervener application with the short cost title. Short cost title.
Brother, may I
You
pay
will
for
from the Sarthak. Why you not?
But may I get a copy of the petition from my?
File it, then we'll see. Let. 3, 4 and 5 also same, you are appearing.
Yes.
You are intervening.
Yeah, right.
4 I am appearing that.
He's so happy. Yes.
Lord, 2,
3 okay, 4, 5 same. Same date.
Yes, same order may be passed.
One only and
बोल
one.
दिया तो नहीं बोला
Grateful, man.
grateful हताश हो रहा
Next.
Grateful.
नहीं वो बोला
Hey, Lord, this call.
Only thing, my lord, if you do 3, 4 and 5, makes it plural so that it's a common order.
Single, no, उसमें not petitioner.
Petitioner, you know what?
3, 4 and 5 petitioner.
Lord, change the wording a little more in each of the orders, not for the benefit of Mr. Banerjee.
That's why specifically is said that. It is singular or plural.
I'm sitting on the same boat.
Yes.
Challenge. Principal memo on the basis of which tender was floated. Condition of just one condition. And lordship, tender.
Who is for the other authorities? Nobody. Served.
You are present.
Yes. Where is the tender?
Lordship, lordship.
Yes. Hey.
Page.
हमारे लोग पानी डालो बोले हमको अच्छा. What is the prayer?
I have challenged what terms and conditions of the main memo.
Where is that?
Lordship, tender is lordship at page 45.
40?
46, lordship. I am challenging page 69.
46?
69. Lordship, can you turn page 69?
69. The tender starts from?
Tender starts from page 48, lordship. The notice thereafter tenders.
Where is the NIT?
Page 50 actually starts, lordship. And now 69.
Where is the NIT? Notice inviting tender, where is that?
Not exactly an NIT. This is the problem, my
This is
lord.
the memo, lordship.
Well, there is no NIT.
This is the memo on the basis of which tenders were floated. I have challenged what terms and conditions of the memo. Lordship, can you see page 48?
My lord, if I may just, my lord, interject. My lord, there is no specific tender that is my main issue, my lord. There is no, he has to challenge a specific tender.
Okay, well,
He's challenging a policy in that.
let me see.
My lord, my lord.
Page 48, lordship.
48?
When my learned friend page 48.
Yes.
Lordship, lordship, it is the Director of Medical Education, Director of Health Services, all issued by Special Secretary. These documents, incorporating all terms and conditions with reference to the subject mentioned above, have been finalized. I am therefore directed to request to take necessary actions to engage security personnel through e-tender process and various health institutions across the state. This engagement must strictly comply with the relevant norms issued by the Finance Department. Copies of the new documents are enclosed here for your perusal. Please note that the existing agency may be allowed to continue service. So this is the main memo on the basis of which tender was supposed to be floated. They have explained the terms and conditions. Lordship, I have challenged one terms and condition of this memo. Lordship, that is page 69.
What is the tender?
Tender, Lordship,
For what work? Which work?
Security personnel, Lordship, third line, page 48. Security personnel. Various
Engage security personnel through the e-tender process, various health institutions across the state. Yes.
This is the tender.
Correct.
This is the terms and conditions we have to follow. Lordship, page 69.
The engagement must strictly follow the relevant norms and rules. Yes.
Page 69, Lordship.
Yes.
The intending tenderer produce credential of similar nature of completed single work with experience providing security services in a government hospital or corporate hospitals, medical college and hospital having been answered. Lordship, I am pausing here, Lordship. Kindly, Lordship, turn.
Item number.
All the tender is 45. Page 45, the terms and conditions of the all the
45. Yes.
3.1.
3.1 years.
The bidder must be recognized security with the experience of providing security service in a government hospital
corporate hospital, medical college and hospital, or any other institution. Lordship, that has been omitted in this statement.
So any other institution has been omitted.
Lordship,
Yes.
my humble submission
Ah.
is narrow down the competition, Lordship, number one, Lordship. And there is so many bidders who are supplying security agencies with different government wings who have much more credential, much more financial strength, they will be ousted. I shall declare one Supreme Court judgment on this point, Lordship. This is the first point, Lordship. And on the basis of this, Lordship, the tender was floated. Lordship, I am just challenging you on the basis of your Lordship, the second point.
Yes.
Lordship, kindly turn that page 122.
122. Yes.
Top Health and Family Welfare Department, Parashad Government Medical College and Hospital.
Yes.
Lordship, kindly come down, Lordship, first, second, third, fourth box, Lordship. Fourth box starts with title, work description, has been, Lordship. Lordship, the tender value in rupees, not applicable, no tender value.
Where from your day?
Fourth box, Lordship, starts with title.
Title Security Service Barasat. Work description services.
Speed, tender value.
Tender value and not applicable.
Lordship,
Yes.
but 6.1, Lordship mentioned that 40.
So what is this?
Yes.
What is page 120, 122?
The tender notice.
Tender notice after the amendment.
After the demo. Lordship.
After this amendment. Proposed amendment. Exclusion of the clause.
Lordship, no tender value. Lordship, here, Lordship, has to be specifically stated that the tenderer has to be, Lordship, kindly just come back, Lordship, page 69.
Yes.
Having minimum value of 40% of the estimated amount per annum due to tender.
Intending to produce the credentials similar nature of completed work, providing security service, hospital, corporate firms having minimum value of 40%.
Estimated amount per annum put to tender.
Correct. During
There
3
is no
years.
Lordship, 122, there is no tender value. This is Barashad Hospital, Lordship. Lordship, 124.
124.
Top, Lordship, Rampura Government Medical College. Top. Lordship, here also no tender value.
Okay. Where you can get?
Fourth column, Lordship, fourth box, same place. Title, work description, NTA, independent external tender value.
Yes.
No tender value. And Lordship, then 128.
Okay. 128.
This is Jalpai, top, Lordship, Jalpaiguri Government Medical College and Hospital. Top.
Yes.
And same thing, there is no tender.
Yes.
Lordship, another matter in mind matter, Lordship, the Lordship directed the authority to put tender value and republish the tender. The Lordship did to it. But first thing, Lordship, the point I have first raised, that is.
So you are at 2 points. With regard to the exclusion of the other institution, second is the tender value is not disclosed. If tender value is not disclosed, how the 40% can be decided? This is your submission.
My lord, as far as the first point is concerned, my lord, whether, my lord, this has been necessitated in view, my lord knows, my lord, the Arjikar incident. There was a great lapse of security during the Arjikar incident. The government took a policy that the governments require specialized security setup, and for such purpose, my lord, security personnel had to be employed, my lord, in the government premises, my lord, not only for protection, my lord, of the staff, the doctors, the medical personnel, my lord, also for other patients. My lord, this also requires, my lord, specialized idea. My lord, just to give an idea, my lord, in several government hospitals, there are huge queues, my lord, outside emergencies. There are huge queues, my lord, outside other places. So these security personnel, my lord, not only, my lord, are to provide safety and security and watch and ward, but also, my lord, ensure, my lord, have some basic knowledge of our hospital functions. Which ward is what side, let's say for example, patients come from very far-flung districts and other places. Poor people, they have to be guided at times. The immediate person who they come in contact with is the security guard at the entrance or at the doors and other places. So these person, so there are threefold reasons for that. But most important paramount is Arjikar incident. Next is to ensure complete security to the life and property of the doctors, staff, employees, patients and visitors, and the assets and properties, including the high-end medical equipment. The second argument, reasoning for that is the assisting the hospital management in the maintenance of day-to-day discipline, the queue management and also smooth functioning of the healthcare activities, and assisting the patients and visitors in reaching. The third argument, the point put forward is reaching the designated locations, including assistance to serious patients and senior citizens, female patients and children, while displaying at the same point of time mature behavior towards female staff, female visitors, patients and elderly persons. So this was the primary reason why this clause was introduced, that there has to be some primary earlier experience of this. Cannot be normal security guard employed in other building, apartments and other places. They will have to have knowledge of this. So this is the reason this was the primary point for which these threefold. The second aspect on which they are saying these three, one should not go by just an extract of the website thing. One has to go through the terms of the tender. They have not disclosed the tender. He's alluded to 3 tenders, None of those tenders have been disclosed in the petition. He's not challenged also these 3 tenders in the prayers. The prayer only deals with this policy of the government. Also he has to demonstrate whether he has applied for those tenders. It's not even mentioned once that I'm interested in Barasat, a government college tender, or Jalpaiguri government college tender. He's not demonstrated that. It's in the nature of a public interest which is coming forward before my lord. Also, another thing which the petitioners failed to highlight, is that all the
No, what is that page 122? The 3, what are
that is just the
documents?
These are page extract, website extracts.
Correct.
Yes.
What are these documents? These are tender details.
These are tender,
Correct.
but the exact one cannot one has to go through the document to understand not necessarily NA writing here, the nature of the tender also needs to be appreciated. They will they will give an idea value.
So you are as per your case, authority has not issued any tender. We are
No. I'm not on that. I'm not saying that.
So mentioning the not availability of the
does not mean necessarily it describes the tender in detail. One has to he would have had to disclose the tender, and he is not he is not in any way affected by it, because he has not said he's applied for these tenders.
Not necessary.
One has to come subject to what falls.
If he applied for, so why he will come? If he find that it is a in violation of the tender condition, he is not challenging that.
Very well. At 122, there are this pre-bid.
That's why you justify, because this is your document. What is this document?
I will. All of these, has also pre-bid meeting. So, if he had, whether he had to disclose whether he attended the pre-bid meetings, that I'm interested in bidding for this, I will attend the pre-bid meeting. During the pre-bid meeting, I will raise these points.
Correct.
That had to be demonstrated.
Correct.
There is nothing on record to show that he had attended the pre-bid meetings and he had said that these are the mistakes, my lord, in the tender conditions or whatever. You've not stated that.
Correct.
So that, my lord, has not been done.
Okay.
Also, he is not, the petitioners also not disclosed. There is another condition introduced that all these security personnel, have to be registered under, the Private Security Agencies Regulation Act of 2005.
Without security, you cannot allow.
Yes. So, these fresh things have been introduced.
See, that cannot be a fresh thing. Security forces, you want to take the person as for the security guard, the agency has to be registered, and he has to pay all the EPF, all the tax, then he has to satisfy the authority, then only that.
I bow down.
That is, but here see, what you have taken the decision due to the RG-car. Okay, I am with you. RG-car is the incident which is very unfortunate incident.
Yes.
Correct.
Gruesome.
Every person resident of West Bengal all over India is knowing with regard to that. But see, if you are telling today Yes, only the persons who is working in this hospital or medical college, there only. So that means if suppose only 100 hospitals and 100 medical college, so and this 100%, so you will not allow to increase the competition.
My lord, yes,
So
my lord, that is there.
this 100 will every time they will continue and
That
they
is-
will get. So
That is, my lord,
this is not a fundamental right of the person.
my lord, yes, subject.
Security guard, the person who has registered and got the license from he had to show before registration, yes, all the equipments, all the facilities.
That was
all
not there in the earlier, which he showed page
No, you're
45.
telling
It was not there.
not there. No,
So he will
not
introduce
that. With regard to other,
my lord.
see, security agency, you cannot say only he who has worked with the medical college or the hospital, he can. So
My lord, as of now,
you are allowing
I bow down, my lord. As of now, my lord, I get it, my lord. Whether the set has, it's a reduced set now. Yes, what has fallen from my lord, and
set will continue.
whether yes, my lord. So, my lord, at this juncture, my lord, just thinking, my lord, beyond this, my lord, just beyond the courtroom for a while, my lord, that whether, my lord, the government also, my lord, from the policy perspective, whether to allow the prior people would have been a challenge from the policy perspective, but still, my lord, the government went ahead and did it, my lord, considering the specialized nature. My lord, I've taken some instructions. Ektu Shaibke diye deben. My lord, paragraph 2 is what, my lord.
Cook diet is not here. Cook diet is not the question here. It is not.
No. Sorry, I'm sorry. Paragraph 3. I'm so sorry. I'm so sorry. I'm so sorry.
See, you are taking the benefit or taking the Arjikar incident. That was happening.
That was playing in the mind in large.
In the large. Similar institution in other educational institution also there.
My lord.
Correct. On all other institutions, there where the female, lady, and the old age persons all are there. So you will say the specialized security service ensure complete security, life and property of doctor, staffs, employees. So this will applicable. Then tomorrow you will come in all the institution.
Others will also come and say whether. So, my lord, here, my lord, I bow down, my lord. Here, my lord knows, my lord, for hospitals, my lord, there have been specialized laws also made for clinical establishments and others. My lord, because of the specialized nature, that is the policy of the government, my lord, where due to the specialized nature of the work, not only watch and ward, my lord, there are other things where one has to be abreast and my lord, know the idea of hospital functions.
Experience of providing security services. What is the security services? So that your hospital should secure.
That was the understanding at one point of time, my lord.
Should secure from entering any,
my lord,
person,
my lord,
not authorized. Correct. The staffs who are posted there, they should secure. The officers should secure. Correct. And you are addressed for the Supreme Court judgment with regard to further safety. The security cannot. Security will only take care of your all establishment. With regard to the further security, your paramilitary forces.
I'm sorry, my lord. My lord, page 50. My lord, paramilitary, page 54, my lord, will be pleased to. My lord, interestingly, my lord, paramilitary, my lord knows, my lord, in Madras High Court, my lord, we've seen, my lord. Page 54.
Take instruction.
Page 54, my lord. My lord, why the nature of the work? What is the nature of the work, my lord? It's been named security service, but what is the nature of the work?
Yes, where is that?
54? My lord, page 54 of the petition.
Correct.
Which is internal page 5 of the, my lord.
Yes.
So, my lord, here, my lord, will be pleased to take, my lord, ABCD.
Correct.
That's the initial, my lord, security work, which my lord was indicating, my lord. Yes. My lord, A, B, and C are the preliminary security work.
Correct.
My lord, D onwards, my lord will be pleased to take. My lord, D, next page, E. Very interesting. Surveillance of control of untoward incidents, especially involving the outside elements.
Correct.
So my lord knows why this came in.
Correct.
My lord, controlling entry of stray cattle, canine, feline menace.
So you do,
no, my lord, I will.
telling.
My lord, now my lord, here, my lord, KL, very specialized work.
Dealing with the escalating post.
M, very special, very interesting, my lord, here.
Correct.
My lord, P onwards.
So you do one thing, once you are publishing the tender,
P, my lord takes P.
you publishing the tender, you are putting the condition, if they will fail, they are not providing.
No, my lord, we cannot take chances in hospitals for that. My lord, that is one, my lord, that is where, my lord, we will have some, my lord, the government has some difficulty, my lord. With hospitals, my lord, here,
Sorry, sir, you, by taking into the consideration of the one incident in the state, you cannot take all the things in your hand.
Not in
and violate the Article 21.
My lord, perhaps, my lord, Article 21 subject to what falls from.
Then I am saying you file the affidavit. Sorry, this type.
My lord, this.
One incident you cannot take.
Not only about
one incident of the West Bengal, you cannot violate the. You cannot debar the any other persons who is eligible. So you put the condition if they are not able to do that, because you are. See, I know you have publishing the tender for security services.
My lord.
Your office superintendent will be the overall in charge to see whether the security service has been providing properly or not. Who is looking after this? They are not the wholesale in charge. The security persons who have been provided under the contract,
my lord,
that has to be overlooked by your officer only. Either superintendent of the hospital or any other officer designated
and the others are in charge. My lord, my lord.
If he found that he is not able to provide all these things, so he can put,
that is why
he can put a notice to the higher authority and issue the so-called notice, cancel the tender, blacklist.
My lord, subject to what falls from my lord, because my lord, here, that is why this has been put in as an eligibility condition. My lord, just to check whether they have this idea or not. My lord, I will take instructions on the point as to whether the government intends to, my lord, whether this is a one-off instance in the tender or in future, my lord, they will want to open it up to a larger.
That's correct. Instead of the deleting the others, you tell that eligibility criteria so and so along with this.
My lord, this is the scope of work.
Yes.
That is why we want to see whether they have this idea or whether they have this experience or not. That is why we put it in the eligibility. That is the reason, my lord.
They will submit the document.
No, that is my credential.
Security services provided to the other government, and the other government has given, yes, he has provided the security and completed the standard. What further remains? What the authority will not say, yes, he is having this security person, ex-serviceman, this man, that man.
Yes. They will not say that. No, of course, they will not say that. No, so that is why, my lord, I will come back on the, my lord, subject to what I will want to come back, my lord, as to whether I will take instructions, my lord, as to whether these specific can, my lord, what propel them any further, my lord, reason, my lord, which
because today this you continue, tomorrow the other institution will continue, then other institution, the whole West Bengal will say no, only if they are working, you are providing the security services in the education, only they are eligible. They are providing the security services in other department, industry department, only they are eligible. They are providing the education, they are only eligible.
My lord will decide whether this falls, whether
the newcomer will not be able to participate in the.
I bow down.
That will be the competition.
I bow down, my lord. My lord, whether this creates an intelligible differential or not is something, my lord, which is a hurdle which I will have to cross before my lord. I will
not hurdle. This is a practical.
I will have to satisfy my lord.
This is a practical thing. I am not putting it. I am.
This is my job, my lord. This is my job.
Your scope of work, you have defined that,
my lord.
This scope of work, how you can, if he is producing, because the tender condition, what the tender condition, he should be a security services having the tender value of so and so, 3 years continuous, 40% of the tender value. These are the things. If he continue, if you provide, then the scope of work, when it will come? The scope of work will come after the tender is awarded and you find that he is not able to provide the scope of work as provided under the tender condition.
My lord knows, my lord, their cancelling, reissuing will be a big
everywhere. Even PWD, even go to the construction work, you go to the metro. the contractor is not doing the work.
My lord, their eligibility, my lord, is strict, far more strict. My lord knows, my lord.
That is also a public service. NHA.
They are very,
Contract is beyond
NHI, my lord,
awarded.
one has to have prior
All
experience.
contract are the similar thing, all, but there are
Yes,
different.
but like
So you
NHI
cannot say the hospital is the different thing only because of the one incident.
Not one incident, that is one incident which propelled the government to ensure there are some special.
I totally
My lord,
agree
because
with
there
that.
was
It's
also
the unfortunate incident, but the government cannot take the benefit of that incident
not
in
benefit.
every
My
matter.
lord, I will again come back with some instructions, my lord, on this point, my lord, as to whether, my lord, we will, my lord.
Yes,
what's-
only see. So you cannot say the other you.
My lord will be pleased to, my lord, just direct me, my lord, record that on instructions, or is directed to take instructions on as to why this was, my lord, on this.
No, but where is the tender?
No.
What is the last date?
No, he's not challenged them, my lord.
What is the
There.
last date? And first thing, have you attended the pre-bid meeting? Show me the pre-bid meeting you attended and you put this condition to the pre-bid meeting. Are you satisfied this?
No, I cannot.
Then, no.
I cannot participate
No.
without knowing the
Pre-bid meeting, everyone.
But pre-bid meeting, XYZ, anybody can
Anybody can,
appear,
anybody
give the
can.
representation, sir, your tender document, provide this is not in
Where is their
accordance with
email, my
law.
lord?
Please correct it. Where is that?
Lordship, I have done that.
Then,
but Lordship,
He's not briefed, my lord.
if they finalize this tender, then it will be an empty formalities, Lordship.
but you lost your chance. You have not come said before the pre-bid meeting. If you have not raised any objection in the pre-bid meeting, how you can file a writ application?
No, Lordship, all
Ideally, my lord, I should have challenged it.
Where is the objection in the pre-bid meeting?
Lordship, before Lordship, Lordship, I have filed it, Lordship, on 17th, Lordship.
Huh?
17 June, I have filed it, Lordship, and so
No,
two, three
this
hospitals, Lordship.
kindly see 122, 128 and
Lordship,
123 which you are relying upon, that is issued in 27th, 29th of May. Correct. Opening on 27th June. And the pre-bid meeting was 3rd June. Then you're not.
That is true, Lordship. I did not attend.
Then you come to the page 124. Pre-meeting meeting was 9th June. You are not
I did not
appeared.
attend, Lordship.
Then you come to the page 128.
Lordship, I did not attend. I did not attend the
Pre-meeting
pre-meeting.
the petitioner has filed the presented application mainly challenging the proposed eligibility, eligible and qualified bidders. Challenging clause 3 of the proposed condition for eligible and qualified bidders, which reads as follows. 69. Concept for the petitioner has drawn the attention of this court to the earlier condition of the tender notice, wherein the eligibility and the qualified bidders as follows. This one, page 45, 3.1. Land concept for the petition submit that now the respondent authorities by way of this proposed amendment intending to delete the right of the other institutions to participate in the said bid. Leonard Council for the respondent authorities submit that by taking into account of the incident of the RG Kar hospital, the authorities have taken the decision, but he is
along with other.
But he is not having full instruction from the complete instruction from the authorities, and as such, he prays for time to take instruction. Let the instruction be let the matter appear on.
The weekends, my lord.
But you are going to publish this. If this tender will be,
these tenders, I think
no, they're not. But the other will be affected. No, then tomorrow you will say that the other tender has been issued. Because today is the 29th. Today is the last date of the opening one of the tender. And another is on 27 June.
But as far as the petitioner is concerned, he will not be affected.
Not petitioner, but
I mean, he's coming more in the nature of PIL before my lord.
Purpose condition will be halted, then the other.
Subject to what? My lord, he's coming more in the nature of public interest litigation. My lord. Subject to what? My lord, my lord.
Matter appear on. आज कितना है? 29. On 3rd July, under the same heading, within 5 matters. ऊपर लिखो affidavit of service filed by the petitioner be kept in the record. Next.
I am for the petitioner. Okay, I am for the
My lord, the
petitioner.
learned ASD is appearing in the matter. He's in some personal difficulty today.
Yes.
The learned ASD is appearing in the matter. Personal
What is the
difficulty.
matter?
Matter relates to family pension of a unmarried daughter under Swatantra Soinik Samman pension scheme. The petitioner's father and mother got pension.
When the father died?
Father died. Father died in 1991.
1991. When the mother died?
Mother died 2020.
Whether your father was getting the pension?
Lordship.
Your mother was getting the pension?
Lordship.
So who is applying now? Daughter? When the daughter applied?
Also daughter.
When your mother died?
Mother died 27th April 2020.
2020. And when you had applied for?
Lordship,
The date is not mentioned, my lord.
When you had applied to, where is the representation?
Lordship. But they have not rejected on that ground.
Where is the
Lordship,
representation?
Page 21. Page, Lordship, kindly. Application. My application. Okay. Page 27. One date. 21st January 2021.
2021. So what has happened to this?
Starting page 24.
What has happened to this?
Thereafter, Lordship, one inquiry was done regarding my
2021.
Lordship.
Page 35.
Page 30, Lordship. 35. Yes.
Yeah. Then.
Grateful.
Then what has happened?
That was submitted before the authority, page 37. 37. Thereafter, they wrote to the 38 page. The chief manager, Indian Bank, to supply or forward the original disbursement portion of PPO such and such.
Okay, madam. When your senior will come?
My lord, kindly keeps the matter on Wednesday. He shall come.
Earlier occasion also took time.
Every time, last occasion also you have taken time.
Lots.
Union of India paid for time. If your Union of India is not having the time, then the court having so much time, the court will decide. Not necessary of hearing the Union of India. Correct?
My lord, this is the last.
Tell your Union of India, this court, once the matter will take, this is the second time, third time with 50 lakh to 50,000 rupees cost. And I will dispose of the writ application. Land Council appearing for the Union of India prays for time. This court finds that the matter was listed on 8th of June 2026. On the said date also the Union of India has prays for time. Accordingly, for the interest of justice, the case adjourned. Let the matter appear on 7th of July 2026 under the same heading. It is made clear that on the date fixed, if none appears on behalf of the Union of India, it is made clear that on the date fixed, no adjournment shall be granted and the matter will be taken up for hearing on merit if the Union of India will not represent.
Grateful. Same position also.
Next.
Grateful.
Your Lordship, I am for the commissioner. I am for the commissioner. And the matter pertains to.
Who is for the petitioner?
I'm for the petitioner. Senior counsel is appealing
Yes.
virtually.
What is the prayer, sir?
Sir, the termination of contract, it is on election weekend, page 259. It is illegal, arbitrary, because the so-called one issue, it was dated.
Where is the impugning order? 16 December 2025. Where is the impugning order?
Well, may I interject, Malad? In this matter, I have been informed by the IIT, Malad, Kharagpur, that they have made a request for appointment of counsel, but nobody has yet been.
No, so you are not appearing?
No, Malad. I have not been properly.
Where is the affidavit of service?
Not been appointed in this matter yet. Malad.
Correspondent number 1 and 2 affidavit has been filed. For 3, the notice was returned for the reason that address is incomplete, whereas it was at the same campus.
No service. There is no service. Where is the service? Where is the service? No service.
Well, IIT has been served. This much I know because they have made an application.
Respondent
for
2 has been served. Respondent number 3 has not been.
No, kindly, what the affidavit of service you filed, madam? You filed the affidavit. Where is the service? Designated Kharagpur Technology. One has been served. Kharagpur Technology is the respondent number?
Possibly, must have been served.
Respondent number?
Respondent number 3 is not served.
Respondent number 2.
Respondent 2 is served.
And who is for the Union of India?
Normally the same counsel appears, my lord.
And 3?
Respondent 3 subject Sachi
No
Ghosh has
service.
not.
No service.
He is a private.
Copy.
Private.
Yes, Mr.
Yeah, yes, sir.
Mr. Their
So
service is not
actually,
affected.
so the
Respondent number
matter
3.
may, so the so-called notice, which is on page 59.
Correct, but the service is no service is affected, sir. So the notice come next week. Petitioner has the service, but it's fine that only the respondent number 2 has been served, but none appears on behalf of the respondent number 2. Then there is no service affected upon the respondent number 1 and 3. The petition is directed to serve the copy of the writ application and serve the notice upon the respondent number 1 and 3, and to file a fresh affidavit of service on the next date fixed. This is the matter on 8 July under the same heading. Next.
Right.
Affidavit of service. Your service wala मामला है. I am appearing on behalf of the petitioner, my lord. Affidavit of service, my lord, kept on record. My lord. My lord, earlier order which is annexed with my writ petition.
What is the matter?
This matter relating to my lord kidney transplantation. My lord, earlier occasion, my lord order was very specific. Give a recent order. My lord, kindly see the.
Who is appearing?
Appearing, my lord. But I don't have any instruction yet, my lord. I don't know if this brief has already been allotted or not, my lord. That is the difficulty, my lord.
Right, start upon them, my lord. And my lord, I will again, but the fact is that, my lord, she is the last stage of.
Correct. I will take. Let us copy will serve.
Yes.
You take.
My lord, may I think in other way, my lord, place this matter in other way. Because of that, my lord, kindly turn page number 55. How unreasonable it is. It will be kind enough if a further police verification, because police verification report there is neither support.
Who are the donor?
The donor is one of the family friend, and he gave the
family friend, not relative.
No.
Where is the police report?
Police report is never supplied me. That's the point, my lord. Never supply me. My lord,
yes, madam, you take instruction whether the police report has been obtained with regard to the donor, and what is the condition of the donor, what is the financial status of the donor. When?
My lord, Friday, my lord.
Have you taken note? What instruction is to be taken?
My lord, may I request in another form, my lord? May I request in another form? It will be kind enough further police verification. Because of that, my lord.
If they're telling that already.
My lord, kindly see the date of the order. That will be, because of that.
Counsel for the petition directed to serve the first copy of the application and the documents to the land counsel appearing for the estate in course of the day. The land counsel for the estate is directed to take instruction whether any police report has been obtained with regard to the donor as well as with regard to the financial condition of the donor. Let the instruction be full stop. Let the matter appear on 7th July.
Can you give a prior date? Because the last stage 5, my lord, last stage.
Nothing will happen within a week.
Okay, my lord, she literally need it. Because this is second time and they are really, my lord, need it.
3rd July. We understand adding. Yes, call the password matter the 2. 1 second. Item 2.
See us with the affidavit services there, but I'm very sorry about it. Okay, kindly seize the tender. This will come back to my lord. This was the.
Yes.
Yes, well, this is the tender for lease of land. For lease of land through MSTC portal by the Port Trust.
By the
Port Trust was leasing out land through MSTC portal. The second highest bidder, the unsuccessful bidder, came to court and said that because of my technical glitch, I could not participate in the NIT.
That matter?
That matter. Yes, ma'am. Now, Lordship, then I came and found that the Port Trust is supporting them, and their unique prayer that let the bidding resume from the point where it stopped. That was not in accordance with the tender term. Lordship did not pass such an order. It goes up in appeal. Appellate court also expressly affirms my lord's order, and says it is for the port trust to act in accordance with law. Now, thereafter, the port trust, knowing full well that they can't resume from that as per tender terms, they give a notice saying that this they are doing as per the appellate court's observation, as if that's a new tender term introduced by the appellate court. Lordship kindly comes to that page 44 of the
44.
Page 44. Page 44 of the writ petition. 45 is the relevant part. 45. In terms of the observation of the Honorable High Court at Calcutta, by its order dated MAT so and so, it has been decided to continue. So if the High Court has made that observation, please continue. Then I should have gone to Supreme Court. That is the whole thing. Lordship kindly sees that the division bench order, my lord's order, was affirmed by the division bench. Page 193. Page 193. Yes. Lordship kindly comes to short order, second paragraph. The writ court could not have interfered with the bidding process once it was over. As it was not within the domain of the writ court to decide whether the appellant should be allowed to bid afresh on account of any technical glitch, which the appellants may have faced. Admittedly, the technical glitch, if at all, was at the end of the appellants and not on the part of the MSTC. That is the platform which held the process on part of the port trust. His lordship had rightly left it open to the port trust to take a decision whether to proceed on the bid received or not, because they had to issue the letter of allotment to me. Auction was held in respect of the land belonging to the port trust. Mr. Basu, Sir Advocate, said that the representation also, paragraph 4 is important. As the lordship has already held, and it is upon the port trust to decide the same issue, decide the issue raised by the appellant. It is for the port trust to decide the fate of the bidding process in accordance with law and inform the fate of such decision to the respective parties. In accordance with law. So, could they have resumed the bidding process from the middle? Lordship kindly comes to the NIT terms. It starts at page 46. Kindly come to page 62. If the NIT terms permitted, they wouldn't have passed the responsibility onto the division bench observation. I will show it is contrary. Page 62. NIT term. Subparagraph B. After the closing time of event has passed, that is 8 minutes, no bid will be accepted by the system. Hence, bidders are advised to make final submission of the bids well within time. No bid will be accepted by the system. It is not that they have cancelled the tender process, then it would have to challenge. Now, Lordship also kindly sees, so after this, they could not have accepted it. Now, Lordship kindly comes to page 83, clause 23. What will they do after the highest bidder? After finalization of the tender through e-tender come e-auction, the allotment letter will be made to the successful bidder by hard copy. This has not yet been done. This is one of my prayers. I will be required to formally accept the NIT.
Yes.
Now, Lordship kindly sees one more thing. Page 122. I have a better copy. This was not very legible. Lordship, I will give the other side also.
122.
122. Now, after the bids were closed. 122. 122. Thank you. Lordship kindly sees the MSTC report. Lordship will see on the left-hand corner buyer reference number, left-hand top. Buyer reference number, Century Infra, appellant, the petitioner. Property given, now auction reference number, buyer's auction status, MSTC so and so. And Lordship now kindly come to the lower box, lot 1, rate so and so, status is sold. Status is sold. Of course, this is not enough. I need my letter of allotment. Now, if they can point to any tender clause which permits them to resume the bidding after a certain point, this will be accordance with tender. Otherwise, the rules of the game can't be changed after the game has started. That is very settled law. And now they have a right to cancel the tender. That is page 62. Page 62, I must point out, they have a right to cancel the tender, which they have not exercised that right. If they exercised, I would take necessary steps in accordance with law. Clause H at page 62. SMP Kolkata reserves the right to cancel or reject or accept or withdraw or extend the tender in full or part as the case may be without assigning any reason. So neither they have cancelled nor withdrawn. Extension doesn't arise because it's over now. Lordship, just for the records, a quick paragraph 26 of that Surat Builders Judgment, Lordship, 2009 11 SCC, page 9 at paragraph 25 and 26. And 25, the prime consideration on which the High Court set aside the award of contract in favor of the appellant is that if the bid of R1 was considered in the tender process, there would have been saving of public money. However, that would not in any manner justifying in going through once again the same tender process, which is always time consuming. Any delay in awarding the contract would next paragraph. WBSEB versus Patel Engineering, this court, while considering the issue with regard to the process of tender L, where bidders who fulfilled pre-qualification alone are invited to bid, adherence to the instructions cannot be given a go-by. Adherence to the instructions cannot be given a go-by, branding it as a pedantic. Otherwise, it will encourage and provide scope for discrimination, arbitrariness, and favoritism, which are totally opposed to the rule of law. Then the quotation, paragraph 31, the contract is awarded normally to the lowest tenderer, which is in the public interest, and it is equally in public interest to adhere to the rules and conditions subject to which bids are invited. It's equally in public interest.
Yes.
Abhay, Lordship, in a statutory regulation was statutory regulations framed to alter the tender process, statutory regulation that was struck down in this Supreme Court judgment. Paragraph, there it was selection, recruitment process. While the recruitment process was going on as per the standards laid down, by regulation, they wanted to alter. Can you come to paragraph 30?
Paragraph?
30.
They cannot change the tender during the process. Yes.
Paragraph 30, the law regarding sanctity of the recruitment process and changes in eligibility criteria and procedure after the initiation of the recruitment process is well settled. In K. Manjushri, this court held the minimum marks were prescribed after the selection process was completed. This is clearly permissible. The rules of the game, meaning thereby that the criteria for selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced. Now, then this paragraph 31, 32. it is the same. I'm not repeating. And also one last judgment on this is the very recent judgment in Golden Food case. You know? So we have not reached that stage as yet, paragraph 32 of this judgment. An auction process has a sanctity attached to it. Paragraph 32. Paragraph 32. An auction process has a sanctity attached to it. And only for valid reasons that the highest bid can be discarded in an auction which is otherwise held in accordance with law. If a valid bid has been made which is above the reserve price, there should be a rationale or reason for not accepting it. Therefore, the decision to discard the highest bid must have a nexus to the rationale of the or the reason. Merely because the authority conducting the auction expected a higher bid than what the highest bidder had bid cannot be a reason to discard the highest bid. In the instant case, no other party had placed a bid higher than the appellant. There was no infirmity in the conduct of the auction. No other party had complained about the process of auction conducted by the GDA. If the bid offered by the appellant head was the highest and above the reserve price, in the circumstances, the said bid ought not to have been accepted by the GDA.
Yes.
And so I'm concluding, summarizing, the writ court, appellate court both held that there has been, that the rules have been followed, tender process is over. My law's judgment is at page 155, and Lordship paragraphs 18, 19 onwards. I think is paragraph. Page 155. My lord judgment, Lordship kindly comes to paragraph 18 onwards. My lord's judgment, which has been expressly upheld by the division bench. And the same prayer was made, let the bidding start. 17, yes, page 163 at the very top. Lordship also held that this is very important, Lordship, I should have pointed this out. Page 163 at the very top. Accordingly, at 22:49:34 hours, respondent number 2 officially closed the e-bidding process. And Lordship held at 164, paragraph 21. The last 5 lines of this page, page number 164. Last 5 lines. The respondents have accepted the bid amount. It is upon the respondent number 3 to issue allotment letter to the private respondent or to take any further decision to cancel the tender process if the authorities found any difficulty to execute. Merely because the allotment letter is not issued to the private respondent without creating right upon the petitioners to participate in the tender process from the stage at 10:40 p.m. along with the other bidders, which is already closed at 22:49.
Yes.
So, my lord, the court did not hold, and then to place the gun on the appellate court decision, where there is no such, page 193, where there is no such decision, clearly shows that the rules don't permit, and they want to pass the, if I may use the colloquial word, buck on the court and do something which the law doesn't permit. Well, this is.
Yes.
Yes, ma'am. Now, my lord, first is, my lord, to make a only for recollection, my lord, in the first round or in the earlier round, my lord, the port trust stand was very clear, not supporting or opposing anybody, saying that port trust will be very happy if it gets a higher bid, higher price. That was the submission on behalf of port trust. Obviously, it will go in favor of someone and go against someone. But being my land, being my property, there is nothing wrong in expecting a higher bid or a higher amount. Now, my lord, please consider, my lord, the arguments which my learned friend is making today was already made and considered by your lordship, my lord, in the earlier round. Please have a look to, my lord, your lordship's order. With the relevant portion is, my lord, paragraph 12 of my lord's order, my lord, at page 160.
You are for the authority.
Yes, I'm for the portress, my lord. I'm the owner of the property.
Page.
My lord, it starts at page 160, para 12.
Yes.
Mr. Mitro Lanet, senior advocate appearing for the private respondent, submits that the petitioners have admitted that there is no technical glitch on the part of MSTC. He submits that clause 12 of the techno-commercial bid. It is specified that the scheduled closing time of e-auction shall be automatically extended in case a techno-commercially qualified bidder submits a bid within 8 minutes of the scheduled closing time of auction. He submits that as per the case of the petitioner, there was a technical glitch in the computer at 10:40. But as per the report submitted by MSTC, the bidding window of the petitioners reopened at so-and-so, and the petitioners got further 4 minutes to participate in the tender, but the petitioner failed to place his bid with up till so-and-so. Accordingly, this part is very important. This is the submission made today also. Accordingly, the bid was closed, and now the petitioners cannot claim to allow the petitioners to participate in the tender process further. Now, please skip a few paragraphs. Please come to the paragraph 21.
Yes.
At page 164.
Yes.
As regards issue number 2, clause 23 of the tender document provides that after finalization of the tender through the tender or e-auction, the allotment letters will be made to the successful bidders by hard copy, and the successful bidders shall be required to formally accept the terms and conditions of the allotment of the lease and remit the requisite advance annual rent. The respondents have accepted the bid amount. It is upon the respondent number 3 to issue the allotment order to the private respondent or to take any further decision to cancel the tender process if the authorities found any difficulty to accept the bid amount of the private respondent. Mere the allotment letter is not issued to the private respondent. I think one or two words are missing over here. Will not create any right upon the petitioners to participate in the tender process at the stage at 10:40 on so-and-so along with other bidders, which is already closed on such and such. Then, my lord, your lordship was, my lord, please not to, my lord, entertain the writ petition. But when the matter goes up before the honorable division bench, my lord, the division bench, my lord, please, your lordship may kindly come back to, my lord, page 193.
Yes.
But please take my page number 194, the third line. His lordship had rightly left it open to the port trust to take a decision whether to proceed on the bid received or not. The auction was held in respect of the land belonging to the port trust. Then skipping over para 3, please take para 4. As his lordship has already held that it is up to the port trust to decide the issue raised by the appellant, it is for the port trust to decide the fate of the bidding process in accordance with law and inform the fate of such decision to the respective parties. The decision will reach, etc. Therefore, my lord, the court, the honorable division bench, my lord, left it to the authorities or the owner of the land to take a decision in the matter. But today, my lord, we have decided, my lord, we need to, my lord, also look into, my lord, the intention of the court also. My lord, the court did not want to close the matter over there or at that stage. It has left it to us. Now, my lord, we have taken a decision. Whether the decision is right or wrong is today before the court. But the first limb of argument of my learned friend, but in my very respectful submission, has been considered in the earlier round, my lord, it cannot be reopened. Whatever was the decision, right or wrong, but it has attained finality. Now, today, my lord, the impugned order is at page 44. What have we done? Please take the first 3 lines, that is sufficient, at page 45. In terms of the observation of the Honorable High Court at Calcutta in so-and-so, so-and-so, it has been decided to continue the e-tender by conducting an extended e-auction. That's all. But we are today, my lord, inviting both the parties, come, have an extended e-auction and get your rights decided. You outbid each other, my lord, we are very happy. Now, my lord, on my powers, whether I have this power as per, my lord, the tender terms. My lord, please take, my lord, page 62H. My lord friend has placed, my lord, B. Please have a look to H. But this is irrespective of the court's order. Had there not been, my lord, any court's my lord, direction, then also, my lord, this was there. SMP Kolkata reserves the right to cancel, reject, accept, withdraw, or extend. Without assigning any, but we have extended it. But my learned friend's right is nowhere, my lord, affected. But I had the power of rejection at page 82. I did not.
Extend means to the what extend the extension?
But extend means, my lord, we are extending this.
Because you have on the earlier occasion, this court while passing the judgment, already held the 4 minutes you are not utilized.
Right.
So you cannot allow the private respondent here to further participate in the tender. Now you can turn over that. Taking another decision, because division bench has only given a free hand to take a decision in terms of the order passed by this court.
Right.
Correct. So whether before this court, your submission I recorded 4 months time was there to the private respondent. He has not utilized that. This court has not allowed.
No, we cannot reopen that.
Whether the authority can set the order
to the observations of the court. Right. I get your lordship.
Under which provision the 4 minutes time has been extended. So that is the free hand to every time. So this, if this will allow, the tomorrow the other party will come. Yes, in this case it was allowed. This case also allowed.
No, please consider, my lord, my previous submission.
Satisfied me how this court can affirm your decision by keeping the eyes closed of the observation made by this court in page number 160, paragraph, page 10.
Yes.
164.
164. Yes.
Accordingly, the 22, 49, 34 hours, the respondent number 2 officially closed the auction.
Right.
Clause 16 of the tender also specified neither the respondent nor the respondent number 3 shall be responsible for any problem at the bidder's end, like failure of electricity, so and so, which may cause inconvenience to the prevent bidder. So then, thereafter, this court has taken. Now, page 165, the respondent will not create any right upon the bidder participating in a tender 1042. 60. So you have not utilized the 4 minute time.
Yes,
so
that was the petitioner over there.
The order passed by this court by taking the decision of page 46.
Yes. Yes. Now may I submit. There could be two situations. One situation is nobody had come before the court, and Miller take a situation nobody had come before the court.
That is different.
Yes.
If the nobody has come and he would have been taken the decision, this is the authority. But earlier you kept mum, party came before this court, matter heard on merit, taking into consideration of both the submission. Now you can ignore the findings which has been upheld by the division bench, can ignore that finding and you can make fresh decision.
Now, Millard, my respectful answer would be, Millard, number one is, Millard, the tender conditions permit me to extend.
That's what extend means what? Yes. So if that extend, so why you have not taken the benefit of that extent at the time of arguing on the first round of the litigation?
Now, Millard, please consider, Millard, whether, Millard, I am debarred today from exercising that right or not. Millard, the Honorable Division Bench, Millard, had permitted the KOPT to take a decision on the bid.
Correct.
Now, this decision can be, Millard, in any 3 or 4 ways, Millard, as have been provided in that clause H. But I could have cancelled the entire tender. But I could have extended the tender. I could have rejected the entire bid and gone afresh. Millard, I have taken a shorter route. I have taken a shorter route in the sense that, Millard, I have extended it.
Yes.
Now, Millard, question is, Millard, if, Millard, the decision is within the parameters of the tender conditions, Millard, whether, can you please consider, Millard, whether, Millard, it calls for any interference or not. Millard, please look at it from this point of view. If the division bench has given me this liberty, I could have cancelled it.
But the division bench simultaneously has stated that the order passed by this court has not
Rightly not
interfere.
interfered. Right,
Not
right,
interfere.
right.
Then
Absolutely.
and this
absolutely.
court is having the finding the 4 minutes you're not you're not you the private husband not utilized.
There's no dispute on
So
that.
how the after the finding can you overturn your submission when the court has come to the finding?
With respect, Milord, there was no decision so far as Kolkata Port Trust is concerned. But the state.
No, you are argued on the
No.
2 days I have given choice to you. Tell me, you have stated that it is up to the court. Then the court has to decide on law. The court has decided on law. Now the port authority cannot say we have taken the decision.
Could I say this, Milord? On the last occasion, Milord, your lordship was judicially reviewing, Milord, the decision of not port, the decision of MSTC. Whether MSTC allowed them that extra 4 minutes, whether there was any glitch on the part of the computer system of Mr. Basu's client, or it was at the end of MSTC.
Correct.
Milord, at that stage, Milord, my decision was not under challenge before your lordship, because MSTC initiates and concludes the process, selects the highest bidder, and refers it to me, because I don't have the mechanism or expertise to undertake this tender process. Therefore, what I respectfully submit is, Milord, had there been any latches on the part at the first stage when we were litigating before your lordship, Milord, your lordship was scrutinizing, Milord, MSTC's stand. Now today, Milord, I am being the owner of the property, Milord, I had, Milord, certain rights. That is why it is written SMP. Milord, SMP's decision was not under judicial scrutiny at that stage.
But SMP appeared and made submission.
Yes.
SMP has not taken the decision at the time. Yes, we will extend the time.
Yes.
So MSTC could have been, yes, they are extending the time, then we can extend the time further.
Yes.
You have your submission is recorded, Mr.
Yes.
Mr.
Now please
Tatto.
take my submission at para 7 of your lordship's
Yes.
order. Please have a look. But my submission was clear that I am interested for the highest.
Highest, but yes, highest, but the Supreme Court, it is against the Supreme Court judgment. The highest cannot be. So you have not taken the decision on that time. Yes, he is the highest bidder. I am extending MSTC can allow you.
I will distinguish that decision of my learned friend immediately. Immediately. Please have a look at paragraph 7.
Yes.
Page 158.
Yes.
Para 7 so and so submits that due to technical glitch, the petitioners were unable to participate in the live so and so. And if the petitioners, this was my submission,
is intending to pay
a higher bid amount, then the private respondent and the respondent number 3 will consider the same in accordance with law. My stand was very clear.
Okay.
And definitely, this stand is going to favor somebody and will go against someone. But I am interested about the highest price.
Okay.
Now, Milord, your lordship may kindly look into, Milord, the decision which my learned friend has placed. If your lordship so desires, Milord, I can come back at 2 o'clock and distinguish it.
Yeah.
But there is a 2 p.m. fixed matter.
Yes.
Yes.
Fixed matter is there.
There's a 12 p.m. fixed. 12 noon fixed also. And maybe come back at 2. The Bengali expression is Barota beje geche.
Already Barota hoega. Just come at 2, we'll see.
Right.
We take not more than 10.
For me, Milord, 5 minutes.
Item 12.
than your lordship on 24th. So we have prepared the affidavit over this weekend and served it to them. If your lordship kindly takes it up on any other day, then
The number?
and the interim order is till the 2nd of July.
36.
Interim order is till the 2nd of July. Any other day, my lord, we can file the affidavit and.
Learned counsel appearing for the bank has filed the supplementary affidavit after serving the copy to the learned counsel for the petitioner. Learned counsel for the petitioner pressed for time to file.
No, I am filing it.
Petitioner has filed the reply to the supplementary affidavit. Let the same be kept with the record. Though the matter is specific today at 2 p.m., but due to paucity of time, matter could not be taken up for hearing. Counsel for the petitioner submit that the interim order is till 2nd of July 2026 and submit that if this court fix another date, the interim order can be extended. In view of the submission made by the counsel for the parties, let the matter appear on 26th August at 2 p.m.
2 months, my lord, we are going.
এটা 12 নুন কি আছে কি?
প্রকাশ করে দিই করতে বলছি।
27 July at 12 noon. Interim order is extended till the next date of hearing.
I'm great.
Yes.
এটাই তো আসল স্লিপ।
Yes.
Now, my lord, on the judgments which my learned friend has cited, so please take, my lord, the first one, 2009-11 SCC. Whatever may be the facts, my lord, over here, my lord, pre-qualification documents, my lord, certain documents were not filed. It was belatedly filed. The High Court had granted certain directions which has finally been considered by the Supreme Court. Please have a look to, my lord, paragraph 25 and 26.
Yes.
The prime consideration on which the High Court set aside the award of contract in favor of the appellant is that if the bid of the respondent number 1 was considered in the tender process, there would have been saving of public money. However, that would not in any manner justify in going through once again that same tender process, which is always time consuming. Any delay in awarding the contract would only mean increase in the cost of expenditure for the cost of construction, such and such. Now, Supreme Court may also considers, as I was saying, Lord, I could have gone for a fresh tender also.
Correct.
Now, Supreme Court here also considers that in going for a fresh tender, it delays, time consuming, more
that
money.
is a submission.
Yes, yes. No.
Prime consideration whether it is
on which the High Court set aside was so and so. However, then Miller from however subject to correction by my Lord Miller. However, this Miller Supreme Court's observation. However, that would not in any manner justify in going through once again the tender process, which is always time consuming. Then Miller in Patel Engineering, Miller, I don't think that would be of much relevance, Miller, so far as we are concerned in our case.
Okay.
Then it says that the High Court erred in Millard acting as an appellate body. Now, please take me the second one. But my case is that I have chosen one of the alternatives that were available to me under the NIT terms. Now, the second judgment, our Patel Millard, here Millard, the rules of the games Millard was changed, which is essentially a service matter. Millard, the eligibility criteria was changed in between. Please take para 30.
Yes, changing of the criteria.
Yes. I have not changed the criteria in the sense that I have put in some clause or removed some clause, Millard, which tinkers with Millard the eligibility process or etc. Therefore, Millard, this judgment also, avoid Millard in my respectful submission would also Millard not be of any assistance to my learned friend's client. And the last one is golden food. Please have a look to paragraph 32 of this judgment.
Yes.
An auction process has a sanctity attached to it only for valid reasons that the highest bid can be discarded in an auction which is otherwise held in accordance with law. If a valid bid has been made which is above the reserve price, there should be a rationale or reason for not accepting it. Therefore, the decision to discard the highest bid must have a nexus to the rationale or reason. Merely because the authority conducting the auction expected a higher bid, that is my case.
Correct.
Then what the highest bidder had bid cannot be a reason to discard the highest bid. In the instant case, no other party had placed a bid higher than the appellant herein. There was no infirmity in the conduct of the auction. No other party had complained of the process being conducted by GDA. The bid offered by the appellant herein was the highest and above the reserve price. In the circumstances, the said bid ought to have been accepted by GDA rather than cancelling the same without notice to the appellant herein. In the cancellation of bid, subpoena is well. But we are, Miller, before your lordship, with a case where, Miller, the bid is not cancelled. We are not before your lordship with a case where nobody has challenged the process. Miller, your lordships have considered it. But I have 4 alternatives. I have chosen one of the alternatives by extending the time. And this is in tune with what we had submitted in the first round, that I am interested with a better price. And this is what I am doing. Therefore, Miller,
with regard to the extension,
yes, sir.
how you give the extension to all?
No, there are 2 bidders only.
That is the problem.
Yes, there are 2 bidders only.
2 bidders, why you extension? Go for the competitive.
No, I can go, but there is no doubt about that.
I thought 2 and you
Yes.
know one is the highest bidder, then you giving. So you go for the fresh tender. Only 2. It is not the all.
Yes, but as I said, not rely upon that judgment, the first judgment period. If new tender will consume more time, it's better, Miller, there are 2 parties.
It is not anything. Only the giving the list to the party. What public interest involved?
Miller,
it is giving the your landed property only. Is there is no public interest? There will be a delay.
Miller, there is going to be delay. Why? Miller have to re-engage NSTC. Number 2, Miller, advertisement have to be published.
On the first occasion, your view was different. MSTC was different.
Yes. Yes.
Now you have taken the. Why you have not taken the decision on very first day when the case was filed? Yes, we are extending. Now after the so many litigation, the court has come to a finding, and you are overreaching the findings of the court and cancelling. That is troubling to this court.
Please consider once again. Please to observe that hours also.
Your authority can overreach the finding of the court. That is not the stand before this court. Yes, we will extend. So MSTC out to have, if you extend, you could have been given the letter, let it be continued. That was not the stand before this court on the earlier round of litigation.
Yes, because at that stage, Millard, it was completely within the domain of MSTC.
Now again, this will again the MSTC has to conduct. Not by you directly.
Definitely not. MSTC has to conduct. Then
only 2 parties.
This honorable court, my lord, as well as the division bench, had left it to us. Now I cannot concur with the selection. I mean the tender process which is being conducted by MSTC. That is not within my domain. What is within my domain is that after everything I can take on the 4 decisions, and I may have taken one decision. Please consider, Millard, whether Millard it is so arbitrary that Millard it requires Millard a judicial interference by this honorable court. I will be very respectfully submitting Millard. This was one of the options open to me. Millard, I had Millard adopted one of it, sorted to one of it. Why not go for a fresh tender? It's only to Millard avoid the delay or to undertaken once again, Millard, we have adopted. But Millard, this is not to favor anybody or to disfavor anybody.
Okay.
These are my questions.
Thank you.
The day, my lord, I was in the appellate court, I say, why you are preferring the appeal? My submission was before the court, my lord, I have astonished why this appeal has been preferred. Telling, affirm this order, only I have a demand for justice, let it be considered. What is troubling to your lord of mind, which I did? My lord is thinking that your lordship's order has been overreached by the order. Or that my lord, as or in technical sense, my lord is thinking that this order is a product of res judicata. Let us see, my lord, what is the writ petition filed. I am reading for my lord. There was a prayer that I should be participant and paid for a mandamus. My Lord Court, affirmed by the division bench, said, no, you have no right to participate.
Correct.
You have no right to participate and a right to maintain a writ petition, have a mandamus from the court was a subject matter of consideration.
Correct.
Kindly allow me to say, not whether the court trust can allow me or anybody to go for that. Your lordship's consideration was, you have no right to pay for a mandamus in a court, whether you should be allowed to participate in spite of that breach. That was decided.
Correct.
What you decide?
Correct.
That has been affirmed.
Correct.
So my humble submission, my lord, the observation of my lord, can be reconsidered. Whether is there any finding of the court which the court had overreached? According to my humble reading,
Under which law, if the glitch time you have not, the time you have not spent for 4 minutes, can the authority arbitrarily allow you to again you participate?
I'm coming to that. So
You do that. That is the only answer.
that was
Because the earlier occasion, MSTC has taken a specific stand. Once the time is closed, they have not utilized that. It cannot be. Now the port authority can allow the MSTC, no allow continue. So whether this will not take will a wrong signal for the other tenders? No, not in future, because this point has already been decided up till the Supreme Court. Once the time you have not utilized and it is on your part, there is a lacuna, the court cannot.
that's the point.
Yes.
The lordship has rightly not decided that point.
Not decided.
No, can you
Yes, kindly come to the page 21.
whether, my lord,
Kindly come to the page 21, sir. Paragraph 21.
whether, my lord, it was my fault or anybody's fault, my lord has not decided.
No, that is decided. Kindly come. Page 16 onwards, you read that. Paragraph 16 onwards, 162. 2 issues are there. Page 161, there are 2 issues. Whether even the computer system of Peter suffers technical glitch during e-auction process. Page 161, last paragraph 15. There are 2 issues. Yes, 2 issues. Kindly come to one issue.
Yes, but there is a technical glitch on the part of the auction. Respondent shall be responsible for the same.
Correct. Now,
Whether if the respondent C has not finalized the tender of the private respondent, the petitioner can be given an opportunity to participate in the said auction through online from the stage of bidding of 1040.
same. So this court has decided.
What is the lordship finding?
Yes,
Can
kindly.
come.
Now onwards, 16 onwards.
Yes. After all, my lord has not decided subject to correction. Otherwise, my lord
Page paragraph 22.
Paragraph
22.
Yes, 22. I am 21 my lord, before that.
Yes.
Come to 21. As regard to the issue number 2, clause 23 of the tender document, provided that the after finalization of the tender through e-tender or e-auction, the allotment letter should be made to the successful bidder by hard copy. And successful bidder shall be required to formally accept the terms and conditions of the allotment of the lease and remit requisite advance annual rate. The respondents have accepted.
Now this paragraph you right.
Yes.
The respond.
The respondent number 3 to issue allotment order to the private respondent or to take any further decision to cancel the matter, the tender process, if the authorities found any difficulty to accept the bid amount to the private respondent.
Yes.
Pause there for a moment.
Yes.
This was the issue. This issue, whether it is upon the respondent. Number 3 to issue allotment order to the private respondent or to take a further decision.
Yes.
That further decision has now been taken.
Cancel, either to accept or cancel, not extend. That's why I am again and again I put notice to Mr. Datto. The extent has not been submitted before this court, either MSTC or Mr. Datto at that time. And that's why this court has given 2 options, either to cancel or to allot.
Yes, my lord. Subject to correction, my lord. Yet, clause H of page 62 has not been considered. Kindly once again look to 62. What it says? What's the meaning of extension?
Extension, see, extension can be, but here the problem is it is not with regard to the fault of the port authority. It
Not decided that. Whose fault it is? This time,
challenge. I am the last court. If the authority want to overreach of my finding, this is the last court to accept the submission from the bar. Yes, yes. Let the appellate court decide it.
If it is, my lord, even if, my lord, I find that is.
That's why I am feeling your authority overreach, and there is I don't want to open the mouth. I don't want to use the word. This is the very otherwise I could have been passed the other order.
Subject to this, my lord, this is, I don't find subject to, my lord, observation, my lord. Here also in this paragraph, it is upon the respondent number 3 to issue allotment order to private respondent or to take any further decision.
Correct. Two option given. Two option given. Yes. You have not stated on that, my lord, there is a provision of extent. No, and even okay, you show the appeal, whether they are in the appeal you have taken the decision for extension. Show the appeal, there is a ground of extent, they will extend. And this court has not considered with regard to the extension.
Preferred, I say.
No, I am telling, if you are telling that this court has not decided the issue of extent, whether that issue was before the appellate court in any of the ground.
My lord has kept it open.
No, a court has decided. There are only two consideration has been given to you, either to the authority, either to cancel or to assert.
Neither my lord's matter, not mine.
No, but I am very serious if the authority wanted to overreach the order of the court. I am serious on the matter if the authority or any of the court officer.
Again, there is a glitch, I want to remove it. There is no overreaching.
Overreaching. I am telling, yes, satisfied. I am hearing you.
No, I know that. So, my lord, this point.
I know, sir, how the tender process is dealing with the authorities.
Who else knows more than mine?
Then no, I don't have no. I am, but I know.
And I know.
And this order reflects.
This. Yes.
If you are very clean and very clean in hand, why you not cancel it?
Supreme Court says time consuming, nothing else.
What is that? Is not any what we say, any project you are getting delay, and that is not the ground, and that is not the ground in this. Only you are taking the, and in the page 45, that is not with regard to the clause H. That is only with regard to the interpretation of the division bench order. Kindly read the 45.
No interpretation. Court.
Kindly read this.
They are not supposed to, they are not supposed to interpret the division bench order.
Kindly see. Yes, but the division bench has not stated that extent. Take decision.
No. Kindly read us. Revise, reserve base price for the extended of year of such paragraph. You are therefore requested to participate in the extended year. It is not quoted the order of the division bench as if division bench or my lord has said to extension. No. It said you have the power. If you have the power, do whatever you like. Okay, I did one thing. You are therefore requested to participate in the extended auction. Scheduled to be held now financially. Now, my lord.
So, okay, leave aside that. Leave aside that. Then another question arose. Okay, I accept both of your submission. It is a admitted, it is a settled law. If the court finds or it is admitted that a glitch is from the side of the tenderer, contractor, correct? So neither the authority is not liable for any extension or non. Here the court has already decided that this only glitch is your fault. If today this type of this application will allow, so tomorrow what will be the effect of the other matters with regard to the similar nature?
May I answer?
Yes.
If there is fault on my part also, if the power conferred in the tender condition.
That's why I'm asking Mr. Datta has not given the reply. What is the meaning of extent? What is the meaning of extent? Extent of any what will say, any violation of the party. Violation conduct of the party. If the party has violated in the terms and condition, he has not fulfilled. can the authority extend that?
Metal engineering says is substantial compliance will do. But now, my lord, I am absolutely with my lord. But what I am saying, my lord, this is a commercial contract. Supreme Court time without number says that commercial contract is authority is the base that the tender process floated. Only 2 persons participate because the others have no credential to participate. Today, 2 persons participate. And both are before my lord asked for the bid. The commercial rate, commercial will be high. It has happened in court. It is not that it has never happened in the court. There is no other party.
No, I am not on. I am not on. I am telling that once a law is settled, if a party has violated or not qualified, correct, in terms of the tender, and the authority have opened the bid, and the other party came to the court, and the court has also affirmed the whatever it is, can now the glitch, the extended time, by this order, can you extend the time?
For example,
That extension is with regard to the any law.
for the timing, my lord, can you see it is not extended, it is cancelled. Cancellation the court trust can do.
Yes, that's what I'm telling.
Tomorrow there will be tender and participant will be 2.
Maybe.
Why? Because now the price has reached, my lord has seen that price. That is separate aspect. So now the participant will be 2. Even if tomorrow there is a
2, 3, that neither the court will see nor you have to see. That the authority will decide. That the authority will decide whether 2 or 3 or 4.
Because I say why I am saying that, because the condition of the tender which was floated, only 2 participants was there, and the 2 participants is contesting. But tomorrow, if it is the tender is floated, now this price is known to the other party also.
Naturally.
So other parties by no means will come.
Maybe.
Then 2 will be there.
We cannot anticipate whether the other party will come or not.
That's the problem is, my lord, if this amount, today there are 2 parties. And my lord can also try what is the price, the revenue, is the revenue generation is the signing one norm for the commercial ventures of the government. Can you see what is this? And you will ultimately find, well, I will not go to the merits of the case. When the bidding was going on, the bidding for the other side was 100 rupees, 10 rupees. Our bidding was much more than that. This is a trend which is going on. All of a sudden it stops. If today, my lord, if cancellation is happened, then time consumption, expenses, that will be there. But that I want that making the submission if they have the credential new tender is come, because they have not come. Because they think they are not eligible to compete here.
No, that the court will not go into that. This court is not going.
That's
My only worry is with regard to once the court has stated that you have not utilized the and at that time the port authority was before this court and the port authority has not taken that, yes, we can extend this time.
No, they have not said so.
Correct.
They are on that date till today they are saying we have the power to do this. That subject to correction, my lord. I was not there with the trial. We could not see with the second bench. This point has not been urged whether clause 8 giving a power or not. That was not urged, my lord.
No, if the extent was there, so why the port authority of no? Because this is a document of the port authority.
They could have on that date signed and extended.
Correct. Even before the division bench also they are not.
And the issue has not been canvassed. In spite of that, I don't think that is justified
Okay.
on this point. These are the only 2 points.
I am not on res judicata. I am not on res judicata. Again, I am putting you. I am not overreaching you. Leave aside. lower side you leave aside, whether the person who has violated the condition by not utilizing the 4 minutes, can the authority, by taking into consideration after the court's order, take that extend word and allow the parties to again participate?
One answer. What is the court order? Court say you court trust, you utilize your power.
But see,
Court has said anything.
division bench order merger with my order.
Certainly.
Correct.
But my lord has not said
And
that.
my order giving two options to you, either accept or cancel.
That is my submission when we are
And you are not filed. This is not a review application from your side or the fourth authority the court has not taken.
The question is, which my lord has put the question, whether the order passed by the court authority by extending time to rebid is within the domain of Calcutta Port Trust, and coupled with your lordship has decided that point that you cannot exercise the power of extension. If that is decided, I have no case.
Okay. Yes, Mr. Mitra.
It has not been decided.
What is extension means? One clarificatory sentence, only one. I said it made in the first half. Below the the explanation.
Okay. Yes.
Shall we come to 197?
What? 197.
197. The
Yes.
session was closed on 24th May. Yes, 24th May. On 29th May, my lord, kindly come to 198, last column.
198.
198. 472 to 67.
Yes.
After, if it is closed, then it cannot be increased. So it means.
No, what? I could not understand.
Kindly come to 198.
Yes.
Highest quoted fee in e-auction, 445 on 24th. Because I was out on that time.
Yes.
445.
Yes.
Then, my lord, kindly see the next column.
Yes.
Revise the bid. That means it is not closed.
What a portion of
Amount has been increased.
how?
Our case is that it indicates that bid has not closed. Can you see the over what is written there? Your consent to the division of the area of the subject plot.
No, that apportionment, taxes extra. Taxes extra, Mr. Basu.
No, apportionment bid for allotment.
Taxes.
Plus taxes extra.
So how this apportionment bid has come?
445 is the highest bid.
Where is the original bid?
Original bid can come. That's it. 115.
100?
115. Bid amount.
115.
115. Serial wall, Century Infra. 445.
445. Yes.
This is the last.
Correct.
And it will tally with 197. Page 198.
Yes.
Thereafter, my lord, this amount was court quoted this amount.
So how?
472.
No. How? What is this? Page 90, 197. What is this?
This is, my lord,
What? To whom? To whom?
quote to him.
To whom?
Mr. Mr. Client.
Yes.
Allotment of land such and such.
Century Limited emerged the highest bidder in the auction. He conducted itna.
Date.
Subsequent to a consent of the revision of.
To the revision.
Yes.
So it has even again revised.
Correct. Revision of the area. A plot as conveyed by your email letter is revived. Inform that the annual rent corresponding to your highest quoted bid in.
If it is again revised, that means it is not closed. Whether I will not get that chance.
No. But you are not made it to that case.
Now it is comes out. Well, I am ready before the read court, my lord. The documents are there. I am not on how it is revised. He said he has given a chance of revision. If a chance of revision has been given to Mr. Mitro's client, why I should be debarred?
Okay.
And this is not confirmed because second paragraph says you are requested to confirm.
Where?
The second paragraph, first paragraph is further and second paragraph in this regard.
In this regard, you are requested to confirm within 5 days from the
Confirm.
unconditional.
Then revision, then request to confirm.
Yes. And what is the date of my order?
24th.
24th, 23rd of
23rd.
23rd. And what is the email dated?
This date is 29th. It was for the first time, my lord, it was disclosed.
Yes.
Thank you to our landed assisting, my lord. It was also I.
Yes. Anything further?
Oh, what? Oh, he has also, my lord, in the demand for justice, he said in page 196 that he want to participate in the bid.
Who?
196, that is a demand for justice under the rules. He has made that. 195 it starts. Can we come to 196?
Without prejudice the above said, without admitting the legality, validity, communication 24th, in the event your good office nevertheless proceed with the proposed auction process on account of the extremely limited time available and leave us with no practical alternative.
No, without prejudice, but they want to participate in the bid. It's a bid head.
Participate in the, without prejudice to our rights and contents. Yes.
Let the bid held. Let us come back with affidavit. Let them now finalize it. At least my lord can see what is the amount court will get.
Yes. Next.
196, my lord. 198 I have showed only for the purpose that is not finalized. Even after 24 your lordship's order, these has been revised. If it is revised, then I am entitled to a participation. I will consider these aspects.
Yes. That's all. Yes, Mr. Dattu, what do you want?
There's only one sentence.
No, you tell me.
Yes.
Because on the last occasion,
yes,
the bid amount was 445.
Right.
Correct.
Yes.
And the court has taken into consideration of 445 and whatever the order is passed.
Right.
Subsequently, you have negotiation was held between the successful bidder and you have revised your rate of 472.
Yes.
How it?
But that is not a revision. But on Millard measurement, it was found that the land which was initially put up for auction and the land physically, there was a difference in the area. That is why it got reduced. I don't think that would make much of a difference.
Where is the correspondence? Divine annual correspondence, highest bid quoted in proposal.
But initially, $44. If your lordship may kindly take me page 198, there's a table in between.
Yes, yes.
Please take the left-hand side column, extreme left-hand side column. Tendered area was 48,258. Revised area is 44,790. Therefore, not everything would change because
revised area is reduced.
Yes, yes.
Revised area reduced, not it's extended.
No, Millard, this was, what is this letter? This is a letter of confirmation of acceptance. Kindly have a look at the subject.
That's called negotiation.
Yes.
You
No,
had a
not for negotiation. But I'll not mislead the court. It was not for a negotiation. Kindly take, Millard, the last penultimate paragraph or the paragraph before that. They are asking for the confirmation within 5 days from the receipt of this communication, your unconditional acceptance of allotment of the revised plot area. This is what is important. Measuring 44,000 at the annual rent amounting to rupees so and so, along with compliance with all terms and conditions. It is clarified that this communication is being issued without prejudice.
That they are not given the final shape.
Yes, that is. Now, the reply to it is My lord, at page 197, top. Yes. Mr. Mitrov's client says this has reference to the below mail. We hereby confirm the below mentioned annual rent of etc. Per annum for revised plot measuring 44,000 and odd, subject to.
No, that is
the right.
25 Jin, 190. What about the reply of 198? Where is the reply of?
190, it is replied at 197.
No, 197 is.
Their reply.
Okay, yes. With reference to below mentioned, and confirmed and below mentioned rent for yes. So he has accepted this.
But our letter was 29th of May. Their reply is 2nd of June.
Yes.
At the top, your lordship would find. I don't think that this would make much of a difference because everything had to be recalculated because the physical area of land differed. So, but my lord, my respectful submission was, my lord, your lordship is troubled by the fact that why did we, that is the Kolkata Port Trust, did not mention in the previous round of litigation that we intend to extend it or cancel it or whatever. Well, my respectful submission is, but I've already said so in the morning, that at that point of time, my lord, your lordship was not scrutinizing my action. At that time, your lordship was scrutinizing the action of the MSTC. Then it was, my lord, your lordship felt that it should be left to the KOPT. And today we have taken a decision, one of the 4 alternatives which we have in that clause itself. Same clause permits me to cancel also.
Yes.
That clause H.
Yes.
Please have a look to my clause 8 at page 62. SMP Kolkata reserves the right to cancel, reject, accept, withdraw, extend.
Yes.
Well, these are my submissions.
Extension, lordship, at page 62, H, clause 62H, SMP reserves the right to cancel or reject or accept or withdraw or extend that order. So what does it mean? Can we see page 48? That would mean the page 48, the timelines, NIT available for one may extend the timelines. It cannot mean extend the bid because of 62 clause B. Because of 62 clause B. It cannot be what is the express bar after the closing time of event has passed, no bid will be accepted by the system.
Where is the closing time?
Closing time is B. Yeah, sorry. That's
49.
it. No, that's
49.
it.
49. Last date and time for submission of the online 5.
Yes, so that can be extended.
And what is the 69?
Well, 62 is that the closing time for each bid. That's clause B. That has to be read with page 95. Page 95, clause 12. That is the bidding time that will not be extended under any circumstances.
95.
95, lordship kindly sees clause 12 and clause B at page 62.
Clause 12.
Clause 12.
Scheduled closing time.
Scheduled closing time of e-auction shall be automatically extended. In case a techno-commercial qualified bidder submits a bid within 8 minutes of scheduled closing time of e-auction. For example, if the scheduled closing time, and see the last line, this extension will go on till no bid is received for the 8 whole minutes. So this is automatically extended for 8 minutes.
Yes.
And this has to be read with clause B at page 62. Clause B. There's an express automatic extension here and closing as per clause B.
Yes.
So after the closing time of event has passed, no bid will be accepted by the system. Hence, bidders are advised to make final. And now, my lord, can they extend the bid after the tender is concluded? That is the next question. Lordship, kindly see, Lordship has held at page 162, paragraph 17. Paragraph 17. The last 5 lines onwards up to 160. The last 5 lines, the last 4 lines of page 162. The system of the petitioner is at 22:45 and the bidding window remained open for about 4 minutes, but even after the restoration of the connection of the petitioner at 22:45, the petitioners have not placed their bid during this 4 minutes, and accordingly 22:49, the respondent number 2 officially closed the e-bidding process. So after closure of e-bidding process, and this is what is expressly affirmed, Lordship will kindly see page 193. This particular part is also the division bench's finding. Page 193, paragraph 2, the first sentence of paragraph 2 of division bench. The writ court could not have interfered with the bidding process once it was over. That's what your Lordship also said, the tendering was over. After the tendering is over, they cannot thereafter, on a misconstrued interpretation of clause H, and Lordship also sees that page 194, third line, his Lordship had rightly left it open to the Port Trust to take a decision whether to proceed on the bid received or not. So not fresh bid. This was Lordship's view. Other option is to cancel, that is page, that is paragraph 21, or else you proceed with this. Yes. And this is expressly division bench has affirmed it.
Yes.
And Lordship will, that letter will also show at page 120, at 197 bottom. After this, how can they take this? Lordship 197, the bottom, the first sentence from trust. This is reference to the tender for allotment of land inside CME compound at 8 Garden Reach, in which Century Ply emerged as the highest bidder in the auction. First, last 3 lines of page 197. Emerged as the highest bidder. So this is concluded. And all of a sudden, after that, by saying division bench order gave me the liberty, he has not justified how. He has now trying where the decision is purely based on the division bench order. Page 48.
Yes.
Sorry, page 45.
41.
Page 45.
Okay. That's all.
That's all. Grateful.
But in B, kindly note the expression system.
B?
Page 62B.
Yes.
Which my learned friend now refers.
Yes.
It is my lord of the system.
Correct. Final submission of the bid within time.
Yes.
After closing of the event as passed on, no bid will be accepted
by the system.
Yes. Hence, the bidders are advised to make final submission on the bids well within time.
Yes. This is this is while the bid process or the auction goes on, whereas H is a subsequent stage. H is thereafter. SMP Kolkata reserves the right XYZ. So I have chosen one of those.
Well, the auction hasn't yet started. Let them not start the auction now. Because the auction was supposed to start at 12. It has not started.
MSTC did not start the auction.
Yes, it's for MSTC to do, not for me.
So Port Trust wanted to proceed and when the writ petition infructuous. The MSTC who saved us. Mr. Thakkar knows that also.
The petitioner has filed the present date application challenging.
Could I take it?
Yes. What is this letter dated? Page 48?
Page 45.
45 is what is the letter dated?
Letter is dated
24 June.
24th June.
क्या बोला? Petitioner has filed the present writ application challenging the communication dated 24th of June 2026, wherein the respondent number 4, has decided to continue the e-auction.
We are respondent number two. Respondent number, I'm mistaken. Sorry. We are respondent number 2 and 3.
Respondent number 2 and 3.
2 and 3 podcast.
Respondent
But 2
number
is
2 and
podcast.
3 has taken a decision, has decided to continue e-auction held on 26 March 2026 by conducting an extended e-auction amongst the techno commercially qualified bidders as per the following parameters. Semicolon. Number A, proposed leased area 44.790 square meter. Number B, reserve / base price for the extended e-auction rupees 4 crore 72 lakhs 67,217, and requested the petitioner to participate in the extended e-auction scheduled to be held on 29th of June 2026 at 12 p.m. through MSTC e-auction portal. Learned counsel for the respective parties have argued the matter at length. Full stop. Considering the above, the respondents number 2 and 3 are restrained from
extended
from holding e-auction on e-auction in terms of the communication dated 24th of June 2026. Full stop. Final order will be passed in the meantime. Detailed order will be passed in the meantime. Not to take any e-auction. 24 June. 24 June. Not to proceed with e-auction process in terms of the communication dated 24 June till the final order is uploaded. 12 noon.
Item 10 only.
Yes.
This. My lord, might kindly take up the matter any other day.
Which one?
This matter.
You are appearing for?
My lord, Mr. Orijit Chakraborty is
I
appearing
am
for
asking, you are appearing for?
Enforcement Director. Mr. Orijit Chakraborty is leading me. He is in another court, my lord.
Yes.
But the primary challenge is not.
But he is asking time.
No, the only what is happening is this petition was filed in 2023. But at that time there was no hearing notice. The matter has been pending with them for almost 30 years. There was no hearing notice at that time. No interim order was pressed. Now in March 2026 during the pendency, they are continuously issuing hearing notices. Now the next one is on 1st of July. So they should not when the matter is before my lord, they should not be really treating with adjudication. The writ petition will be rendered infructuous in that case.
Yes. Only taking adjournment will not serve the purpose. What objection they are raising? You are taking time from this court and you are issuing the fixing a hearing notice before your authority. Then if you say you will not fix the hearing till the next date of hearing, I will adjourn it. Otherwise, you have to argue. It is your option. The court is not taking, and I am giving two options. If you want the adjournment, then you have to say then till the next date of hearing, no hearing notice will be issued. Or if you want to know, you wanted to continue the hearing notice, then you will continue the hearing today. It is up to you. Yes, tell me. You answer. Which option?
My lord,
I have only two options. I have no four option. When is the next hearing? Any notice is issued?
My lord, kindly have a look at this.
First July hearing is there then?
my lord, kindly take up the matter tomorrow, my lord.
It is not possible for this court. Tomorrow the Passover, this court is not having all this word in this determination.
Leave of my learned senior. On the last occasion also this had happened. Therefore, they have recorded in their order. Although there is no stay, they are requesting. So that it be but the only problem is they made our people wait for 6 hours. And the enforcement directorate nowadays is a lot of tension. So if they
Yes, tell me what I cannot see. Can you see the notice? 1st July it is the date. Today we are on 29.
They have
Day
adjusted.
after tomorrow. What is your instruction?
My lord, instruction is with Mr. Chakraborty, my lord.
Correct. So instruction Chakraborty, either they could have been happier. I have not to issue this notice. If the notice is issued, you could have been happier here. But tomorrow you will say without hearing the court has passed an order of stay. That's why I am giving the two options to you. I am not telling that I will not adjourn. I will adjourn the matter, but subject you give an undertaking that the 1st July no hearing will be taken.
My lord.
Yes.
That is my lord.
Correct. You are taken. So you are the junior.
My lord.
You are also appearing in for the ED.
I am junior to Mr. Chakraborty, my lord.
What is the authority? That is also keep in mind. Learned counsel appearing for the ED. Praised for time on the ground that the learned advocate appearing for the learned arguing counsel of the ED is busy in the other court. Learned counsel for the petitioner submit that the ED authority is taking time before this court, and on the other hand they are issuing the notice of hearing. The learned counsel for the petitioner has handed over the notice dated 15th proceedings dated 15th May 2026, wherein the next date of hearing is fixed on 1st of July 2026. Considering the submission made by the counsel for the respective parties and perusing the proceedings dated 15th of May 2026, the case is adjourned when 21st of July 2026 at 12 noon. Full stop. The ED authority is directed not to proceed with the hearing on 1st of July 2026 or any further date till 21st of July 2026. This on 21st at 12 noon as a specific matter.
The same order in the next two matters also. The 32, 30, these are all being heard together.
Yes.
22nd July. Stay.
22nd July, you will not get the time. 22nd.
I think the hearing, they will not hear the matter till
22nd go reason. Fix on 21st, not to fix any hearing till 22nd.
I'm grateful.
Yes, my lord. I am on behalf of the petitioner, your lordship.
Yes.
I have submit affidavit of service and supplementary affidavit. Place on record the latest detention certificate and medical report, your lordship. Kindly see page number 7.
What is your case?
Premature release, your lordship.
When we have been convicted?
Kindly see page number 6, your lordship.
When you have been convicted? Which date you have
2088, your lordship.
2008. And which section?
376.
376. What is the sentence?
A life imprisonment, your lordship.
376 life imprisonment. Whether he was under trial during the he was in custody during trial or
Yes,
he
my
was in
lord.
bail?
Yes, my lord. And
When he is in custody?
kindly see page number 6, your lordship.
Page number Page number 6 of my supplementary affidavit.
Supplementary affidavit.
Yes, my lord.
Page number 6.
Yes, my lord. Custodial certificate.
Date of sentence 3rd November, 30 November.
Yes, my lord.
RI for 30. Life, fine 30,000. In default 1 year.
Yes, my lord.
Additional search. Detention periods 2008 to 2009 as a under trial prisoner. And 30 years as a convict prisoner. 17 years, 10 months, 27 days. Yes.
My lord, here is an instruction, my lord. The petitioner was convicted for offense of rape upon 2 minor girls, my lord.
Correct.
And for continuous period of more than 4 months.
Correct.
Those who used to sleep in the temporary shelter of an NGO, my lord.
Correct.
Now there is a 70th meeting, my lord, and SSRB rejected the same. It's on page 3, my lord.
Page 3.
Yes, my lord. There is no page ignition.
Which section? Which serial number?
Last one. Serial number.
Further action with regard to approval competent authority West Bengal. Department of West Bengal remission cum release order in respect of convict, life convict shall be issued subsequently by the judicial on getting the approval. Where is his name?
My lord, last one.
Not recommended. Serial number 6.
Yes, serial number 6, my lord.
Not recommended at this stage. For what? Victim are now adult and married, but they stay in the same locality.
There is an objection raised from the victim girls, my
lord. No, lordship.
As well as police authority also. Because, my lord, the accused and the victim girl stayed in the same place, my lord. Same village, I think. Same locality.
Victim side, no objection has. Kindly see page number 3 of my supplementary affidavit.
AJ, who strongly oppose this?
Yes. So you got this recommendation?
Yes, my lord. Kindly see page number 3 of para number 11.
Which?
My supplementary affidavit, your lordship.
Paragraph?
Paragraph number 11, 1, your lordship. That the further state a declaration come undertaken execution by the victim side, grandmother of the victim, wherein no objection has been expressed regarding the release of the petitioner. I also annex P2, your lordship. Kindly see page number affidavit. Page number 9 and 10.
Who is Farida Khatun?
She is a grandmother of the VG.
How many VGs are there? 2 or 1?
Two, your lordship.
This is one VG. Another VG?
No direction, your lordship.
Huh? This is one VG?
Yes, my lord.
What about there are 2 VG?
Yes, my lord. 2.
Then what about the other VG?
Other VG, no.
So have you challenged that recommendation? Have you got this? No, your case has not been.
No. Just now, yes. I have received.
So what do you want?
I want kindly reconsideration of the.
They have already taken when the meeting was held.
Yes, my lord.
So now for that 40 convicts matter has been his name is not there. Then your matter is to be heard on merit. So you will file you challenge this?
Yes, my lord.
Where? Have you challenged this non-recommendation?
I want to challenge your lordship. But
when? It is a 2020?
23, my lord.
23?
Yes, my lord.
You not challenge this recommendation.
No, Lord.
Then
9th October 2020.
when you file the writ application, 2025,
2020.
you not challenge that non-recommendation of your premature release. So that remaining file.
Yes, my lord.
So how the court can deal with that?
Kindly consideration for exception petitioner, your lordship.
They have not challenged my lord.
Sir, your case request for premature has already been rejected in 2023.
2023.
Correct. And you filed the writ application
In 2025, your lordship.
You have not challenged this recommendation.
Just now, last 2 months, I brief changed
Your Lordship. This case I have received before in the month of April, Your Lordship. Changing, Your Lordship.
Brief change, the law will not change.
Yes,
Brief
Lord.
might be changed.
We
Law
consider,
will not change.
kindly consider, Your Lordship.
Consideration.
Exception. I want to file an exception, Your Lordship.
What exception? How you can file the exception? It is the prior to filing of the writ application.
Your Lordship.
What exception you will file?
Kindly consider reconsideration of SRB vote.
Why in the this the committee which the meeting is to be held? Why this name has not been taken into consideration?
Well, there is already a number of life convicts. Well, that's why his name.
Correct. So why the other persons, whether the 2003 the persons who not recommended, their name has been taken into consideration? Why the pick and choose manner?
Well, if your lordship please to direct, then we shall.
The court will not the authority to decide all these things. Why you are taking the pick and choose manner? Who is dealing with that? The life convict and all these things. Who is dealing with that? Who is recommending the name for sending it to the review committee? Why? What is the circumstance? His name has not been taken into consideration in the latest after 2023.
Well, they told they take into consideration.
You have to answer. 2023, not 2026. 40% have been taken. Name has been taken. Why this name has not been considered? What is the circumstance? Whether name has been why your name has not been proposed by your jail authority to the recommending committee? What is the circumstances? Who is preparing the list?
I'll come back with the instruction, madam.
Who is preparing the list for sending for the review committee? And what are the guidelines for sending the name to the review board? Of your own, yes, his face is very good, send it. His face is not good, leave it. By face value. Then 2023 his name was, his case was not recommended. Now we are on 2026. Now you are taking the 14 persons for the recommendation. Why this petition name has not been recommended? Or you have given to the committee, in the High Court committee, or send the name to the High Court committee. The petition has filed the present date application praying for consideration of the case for premature release, as the petitioner is in correctional home for the last 18 years, more than 17 years. Learned Counsel for the state has handed over the copy of the 70th meeting of the State Sentence Review Board held on 9th of October 2023, wherein the board has not recommended the case of the petitioner for premature release. Learned Counsel for the state pressed for time to take instruction. Why for the last 3 years further the name of the petitioner has not been taken into consideration, has not been sent to the state review board for consideration of the premature release. Let the matter appear on 14th of July 2026 under the same heading.
March
Yes. Original side, original side.
My lord, before your lordship takes the original side, my lord, may I only make one submission? My lord, item number 11, your lordship had kept on my insistence on Thursday that record of default authentication by information utility. My lord, may it retain its position. If tomorrow 10:30 it can be taken up, my lord, I'm led by Mr. Mitro. He was here. Now the original side is being taken up. I won't tell your lordship, my lord, to accommodate me.
I don't know whether the other matters are within 5 matters, other matters are there, then it will come down. I don't know.
May it retain its position.
It will be in the list. I cannot say whether it will be in the 11 or it may be in the 21. Because my diary, you persons are mentioning, I am fixing.
I understand, my lord.
If the court cannot give your first.
Your lordship, my lord,
you lose your chance today, lose your chance.
Also,
Then the
Thursday,
other
my lord, your
party will-
lordship, I am very grateful has accommodated me
see-
today.
See the diary,
If possible, my lord, I am
see the diary tomorrow.
grateful.
In respect of item number 30
Ah.
of today's list, my lord's list, my lord, the interim order is still today. It's expired.
Item number
30.
30. Record. Who is for the respondent? Though the matter is listed as item number 30 in the today's list, but due to paucity of time, the matter could not be taken up for hearing. Land counsel for the petitioner has mentioned the matter and submit that the interim order is still today. Fine. Interim order. Counsel for the interim order.
Fixed matter.
Till today. In view of the submission made by the counsel for the petitioner, interim order is extended till 10th of July 2026 or until further order whichever is earlier, let the matter remain in the list. Yes.
Much of. Dear. Awesome.
My lord, may I be permitted to mention a matter? My lord, it's an assigned suit, your lordship. My lord, commission
suit
before your lordship, my lord, evidence was going on before the learned commissioner, your lordship. It was last extended in the month of, my lord, February or March, your lordship. My lord, the plaintiff, I'm for the defendant. My lord, in the meantime, after such extension, the plaintiff has caused an email, your lordship, to the learned commissioner and other parties that they no longer wants to proceed with the suit and they want to withdraw the suit. My lord, after that, my lord, so many months have passed, my lord, they have not done anything. My lord, I also have a witness, my lord. It's a very technical issue involved in this matter, your lordship. It's a suit of 1997. My lord, the witness from our side is quite aged, your lordship. God forbid if something happens.
Withdraw and they don't want to proceed with the matter.
My lord, they have to come up with your lordship and they have to withdraw. My lord, it's possible in March. My lord, kindly keeps this matter as to be mentioned. My lord, let them come up and withdraw the matter, your lordship.
I'm for the plaintiff, my lord. We are about to withdraw the suit. I'm humbly beseeching your lordship for a week's accommodation to kindly clear any withstanding dues, my lord. After the clearance of all the withstanding dues within 1 week, withstanding dues of court officers and other costs, my lord, they are due right now.
Standing?
Withstanding dues, my lord.
Cleared since the commission was holding, my lord.
We have not been able to clear the dues, my lord. Hence, I'm humbly beseeching your lordship to.
Who is the commissioner?
My lord, Ishan Shah, Mr. Ishan Shah.
Okay, let it be.
Kindly accommodate a week's time, my lord. In a week's time, we'll clear the dues and withdraw the item.
There.
My lord,
where is the case? आज कितना लेना है? आज 29 है ना? 7 तारीख को to be mentioned top में रख दो.
My lord.
7th July.
7th July.
As to be mentioned at the top, come with the instruction.
Lordship. Grateful, my lord.
Item number 1.
Appear for the plaintiff, the argument of the suit, the defendant comments.
My witness, who had Millard last stepped in the box, so I will have to Millard comments. Lord, may I request your lordship to kindly take the plaint?
You're for the defendant?
Yes, my lord. Your lordship sees
the number?
My lord, I am appearing on behalf of the developer.
Defend number?
That is, my lord, Chirodi Bhattacharya. That is defendant number 2.
Acha, that no completion certificate, that matter?
Yes. It's come back to your lordship, my lord, because the witness action to some extent was before your lordship.
Why before this court?
It is
Specially assigned?
Assigned.
Assigned, Mona, na? Assigned.
Specially assigned. So if your lordship sees the array of plaintiffs and defendants, my lord, your lordship will find that the plaintiff claims herself, my lord, to be the owner of the plot of land.
So you are for the
But
three.
I am for defendant number 2,
Chirandeep Bhattacharya.
Chirodeep Bhattacharya.
Chirandeep.
My lord, Chirodeep. Yes.
And it's C. Okay, whatever.
But there is no N. That's
It is
why.
there N.
My lord, my
There is then again if the degree is bad then
no, this is,
Now I'm
He's
coming up.
the
case
victim.
number 2.
I'm the
He's the
victim.
victim of not mentioning the correct name in the
I'm
contract.
coming up with the amendment now.
CHIRAN.
My lord, I have CHIRA.
That is important. Who prefers an appeal? Who goes up?
I have no intention in preferring the appeal.
Now what is the actual name?
Dada, देखो Chirodeep.
See the evidence. Yes, he has come as a witness.
Yes.
Yes, yes.
Only see the witness का नाम
But
क्या?
CHIRADEEP. There is no N.
CHIRAD. Chirodeep. সাক্ষী দেখো
So why the N is here?
কোথায় এনটা কোথায়
এনটা আমরা পাচ্ছি না।
But in the plain there is no N.
No, written statement.
Oh, that's his.
Where is the
Then he has misspelled his own name.
Well, there are several written statements filed.
Chiradip, okay. Yes.
My lord, in this matter, the defendant number 1 has filed, my lord, is contesting the suit independently. The defendant number 3, my lord, is a pro forma defendant, which is the name of the developer. But the developer, my lord, is being represented by Chirodeep Bhattacharya. That is, my lord, the plaint case. That is how
2 is the developer.
2 is the 2 your lordship will consider as the developer.
And 3 is the company.
3 is the company. They are the pro forma defendant. Now, if your lordship kindly sees the
but the developer in the name of 3.
Development agreement is in the name of 3.
3.
Yes. That is, my lord, how the array of parties has been chosen by the plaintiff. So, naturally, my lord, the question comes that a company cannot be represented by an individual or one director or one person. It has to be, my lord. It should have been properly joined as a party.
3 appeared.
No.
3 not appeared.
No. And my lord, your lordship will see
Someone served.
pro forma defendant.
Writ of notice served.
Has to be. Yes. And added as a party as a pro forma defendant.
Maybe.
Now, my lord, definitely the plaintiff will, my lord, tell your lordship why they chose to make the parties in the manner they are fitted before your lordship.
Oh, yes.
May I, my lord, begin by placing what is the claim in the plaint. Your lordship will find the claims at pages 34 to 37 and 38 of your lordship's plaint. Your lordship kindly comes to page 34. Now, the first claim is a decree for declaration. Lord, very simply, plaintiff is the owner of the land. Defendant number 2 is said to be, the developer. Defendant number 3 is the actual developer because the deed is in his name. There is some dispute with respect to, not the construction, but what has been sold by the developer to third parties. The plaintiff, is aggrieved with that. So, the first prayer is decree for declaration that the registered deeds of conveyance dated August 17, 2010 and March 4, 2011 executed by defendant number 2, that is Chirodeep Bhattacharya, on behalf of the plaintiff in favor of defendant number 1 is null and void.
Who is the defendant number 1?
Defendant number 1 is being represented.
Purchaser.
He is the purchaser of 2 spaces.
And
through
plaintiff is the owner.
Plaintiff is the owner. So, from the first claim, your lordship will be getting an idea or a query whether there is any power of attorney or any authority. I'm sorry,
Defendant number 2 is the purchaser.
Defendant number 1 is the purchaser.
Defendant number 1 is purchaser.
And defendant number 2 is the developer. Defendant number 2 and 3, that is not the correct position. Defendant number 3 is the developer. Defendant number 2 is the person who has signed the deed.
Yes.
Now, my lord, when your lordship, my lord, sees the first prayer, and prayer B is decree directing defendant number 1 to deliver up the registered deeds of conveyances so that the same may be cancelled. So, with my lord, a conjoint reading of these two claims, my lord, raises one query. From which allocation has these spaces been sold? Is it the developer's allocation or the owner's allocation? That is the first query. The second query is, if it is the owner's allocation, did the developer have the right to sell these using that power of attorney? According to the plaintiff, that right is not there. According to us, that right, my lord, flows from the development agreement as well as subsequent documents and conduct of the parties. So this is, my lord, our principal defense. I am giving your lordship, my lord, a nutshell on the first day.
So there is no power of attorney.
There is.
Upon the power of attorney, there is no power of attorney to the developer to sell the property.
That is, my lord, the contention of the plaintiff.
To sell the property.
Yes. And I will have to debunk that contention from the documents available and the evidence before your lordship.
Yes.
If your lordship now, my lord, kindly comes to the next prayer, or next claim, claim number C.
Yes.
My lord, at page 35. Consequent to claims A and B, they have sought for decree for possession against the defendants, and each of them in respect of the portion of the premises in their respective possession as indicated in schedules being annexed F and G. So, my lord, they are not wanting to compromise on the space, they want the space. Now, my lord, D is mandatory injunction directing defendants and each one of them. Your lordship will find there is an alternative prayer for inquiry into damages. They have already sought for damages. And then, my lord, the consequential relief of perpetual injunction. Now I will place before your lordship the plaint and how and what has been pleaded. May I, my lord, kindly place it? The first paragraph, my lord, is plaintiff at all material times was and still is the owner of 71 Surendranath Banerjee Road, Kolkata 7,70,000. Because the premises is within the territorial jurisdiction of this honorable court, the suit, my lord, has been filed here. So, my lord, plaintiff is the owner. There is no dispute to this. The area of the said premises is 13 kothas. Prior to January 10, 2006, there was a two-storied building and other one-storied building structures at the said premises. Now, paragraph 3, defendant number 1 is a company. This is, my lord, your lordship will kindly mark this. This is how they have pleaded. Of course, joinder of party and misjoinder of party is, my lord, consequent on the final stage, because these are not demerable points. But I do have a right to say who ought to have been added as a party and against whom the claim ought to have stood. Just because Chirodip Bhattacharya was a director, one director, company cannot stand in one director's footing, even at that point in time, especially. It cannot be said that the acts have been done by Chirodip Bhattacharya unless there is specific fraud proved against Chirodip Bhattacharya, that he did it in his personal capacity in a fraudulent manner where the company or its management was not involved at all. That your lordship will have to decipher from the plaint itself. In my humble submission, my lord, Chirodip Bhattacharya was never acting dehors of the powers given by the company to carry out the development project. Now, when a project is being carried out, my lord, it is known that there is first a development agreement. That development agreement, my lord, I'm pausing over here only to explain, which has come out in evidence, of course. My lord, a development agreement has several clauses. A few of the most important clauses are the intention which is recorded in the development agreement. That intention, my lord, if clearly understood from the words, your lordship will not delve into it. 1964 Supreme Court is there, my lord. Courts will not delve into such an extent to find out the nitty-gritties or integrities of intention if it can be plainly understood. The second point, my lord, is the allocation.
Where is what are the issues?
Yes. Lord, may I just complete this portion as I was telling you, Lord? I'll come back
See,
to
the only point is that
authority
and on the sale which has been done by the defendant number 2. Defendant number 2 is in accordance with. That is the only.
Plaintiff has said that it ought to have been a residential portion. You have sold it for commercial purpose. The purpose is wrong, and you could not have sold it because I never gave you the power. He has told this in favor of whom is the query which is before your lordship with respectful submission, Miller. He has sold it to defendant number 1. Now, power given to whom? Power given to the company, not to Chirodip Bhattacharya. Now, Chirodip Bhattacharya was a party. Naturally, he had to come in the dock and depose. But all throughout, Milord, he is acting on the basis of the company, because that is the company is the developer. The company will be having power or not having power, not Chirodip Bhattacharya.
No, see, company made a performance independent, correct? And Chiranjeev, and there is no denial that he is not the director or partner or whatever.
There is also no denial that deeds have been signed by Chirodip Bhattacharya.
It's not denial. It is also not denial that you have not signed the deed. So naturally, you acted on behalf of the defendant number 3. Yes. Correct. Now the only question is that whether with regard to the making of the party, that is a question of point of
Only question is on liability.
That's why.
If I suffer a decree, if today your lordship is inclined in passing a decree in favor of the plaintiff, your lordship would want the decree to be executed. That is the principle of any decree.
You prove, it is your duty to prove that you had the document.
Yes.
Which you got the power.
Yes.
And on the basis of the document, you have rightly conveyed or transferred the property to the.
May I put it in this way, Milord? It is the duty of the developer to prove what your lordship has just indicated.
Correct.
And that is absolutely correct.
Correct.
But is it, Milord, the duty of that individual who has been made as a party separately to prove the same or not? That is also, Milord.
No, that's what I'm telling. If you are telling,
we have.
That's what I'm telling. If you are admitting that you are the director or partner, whatever it is, I don't know.
Directly.
If you are admitting that you are the person of the defendant number 3.
Yes.
Correct. Defendant number 3. And you have executed. So naturally, you might have been taken the defense. You being the one of the director, one person of the defendant number 3, you have acted in accordance with the document which the plaintiff has provided. So you acted on behalf of the defendant number 3. Correct. So you have to only prove
that the defendant number 3 had the power.
Had the power.
Yes.
Correct. And he has to prove the power which you acted upon. That power does not given the right to transfer the property.
Yes. Yes. Now I am, Milord, all the acts done by the defendant number 2, either by himself or acting as a developer, is admitted by us. Now comes the question of liability. The question of liability is who is going to be asked
to
perform the claiming and claiming.
Paragraph prayer A.
Yes.
Prayer A. He is not asking any prayer only against you.
But he is asking the deeds which was executed by defendant number 3. Defendant number 3 is the company developer. So if the defendant number 2 is the signatory, he is acting on behalf of defendant number 3. But the relief sought is against defendant number 2. Defendant number 3 is not a proprietorship. It's a company, which is a separate juristic entity. Your lordship's own order is there. I had made the submission before your lordship. But it's a separate juristic entity.
Correct.
So if a decree has been sought for cancellation and delivery up of a document, your lordship will see who are the parties to that. But I asked this question to myself in a humble submission form. The first elementary one, your lordship will find that the party to this document is the defendant number 1, who was the third party purchaser. He claims himself to be bona fide.
Who is appearing for the 3?
The defendant number 1.
One who is appearing for 1.
Now, your lordship will also see that it is the defendant number 3 who has actually executed this document. Whether he had the power or not is a separate issue. We will definitely impress upon your lordship on that. But just because defendant number 2 has signed it, he is not acting on an independent capacity.
That's why you have to show the document.
Yes.
Where is the document?
I will come to that, my lord.
There
As I
are
was-
two things. One is
Yes,
the power
I
of
will show the
attorney.
deed.
First
All
is the
executed.
power of attorney. Second is the conveyance deed.
Yes.
These two documents will serve the purpose whether the defendant number 2 has acted on his own or as a representative of the defendant number 3.
Now, my lord, as I was making my submission, in the development agreement, your lordship will find allocations. What was the intended purpose of those allocations? And your lordship will find that for, my lord, proceeding with the project, the plaintiff had given the inbuilt authority in the development agreement itself to deal with allocations of the plaintiff. Here it is an admitted case, the plaintiff does not reside in Kolkata. She doesn't reside in the country as well. And she has been residing outside the country for a substantial period of time. And I'm told that she is also, my lord.
What is your defense?
So my defense is twofold. First, I have the authority in the development agreement itself. I also have the authority in the allocation document. I had communicated my intention and I had sold it. After selling, I had appropriated the money as was being received, and the money was received by the
appropriated the money.
This is her share. I have given the money back to her. I am a developer. There is no demand for money in that respect, Miller. The claim is not that I have sold and I have usurped the money. I have sold and I have given her her share. So the claim, Miller, only comes after receiving the money, of course. Claim is only that you could not have sold it to this person, a portion which was understood as a residential portion for a commercial purpose. This is, Miller, the intent. Now from here, Mr. Kormakan can take.
But your lordship, I'm sure Lord, Mr. Banerjee has placed the prayers. What are they asking for? Now, Lord, your lordship, it fell from your lordship, Lord. What is my defense? My defense, Lord, is basically threefold. First of the lot is, Lord, I had power to transfer. I had transferred in consonance of the joint development agreement, and in furtherance of that agreement, the power of attorney executed. So two documents in my favor authorizing me to do this act. I have done that. That's one. Second, I have never misused the power of attorney in any manner whatsoever, which will disentitle me to exert my right as the constituted attorney of the plaintiff. And the third, this might not be that relevant in this aspect, but it is. Why, I tell your lordship, specific allegation has been made that I am a director of the defendant number 3, which I say, at that relevant point of time, I was not. So, this basic my submission before your lordship will be restricted to this, because once I am successful in demonstrating before your lordship that I have right, I had the right, I had the authority, I have exercised it in a bona fide manner, the manner in which the plaintiffs thought fit, then I am through, and the plaintiffs in that case cannot today come and assail my act. Now, for that kindly, may I take your lordship? Acha. Lord, your lordship wanted also to see the issues. Lord, the issues on 3rd January 2018 were framed. Lord, may I take extra copy? Have? No,
3rd January 2018.
My lord. Justice Munshi, my lord, had framed it. না মানে ইস্যুস তো ফ্রেম হয়ে গেছে নতুন
No, what the issue court has framed, we have to see that.
Munshis. হ্যাঁ এইটাই তো হ্যাঁ 3rd January. Yes. Lord, I do not know, Lord, subsequent to this, Lord.
No, 3rd January.
Lord, 3rd
No, the
January
plaintiff has to
2018.
2018. No such order.
Take it. Lord, may I hand up to your lordship? Lord, that will be convenient. Issues a copy টা আছে এটা দাও আমি দিয়ে দিলাম খুঁজে পাচ্ছি না এটা ফেরত দিয়ে দেবো So the first issue was, my lord, whether the power of attorney dated such and such at all conferred upon the defendant number 2 any authority to transfer the suit property by way of sale or otherwise to deal with the same in such and such. So, my lord, that's my first defense. I indicated to your lordship. Second, whether defendant number 2 ever had any right or authority to part with the possession of any property. My lord, this basically both are same.
Interchange.
Whether defendant number 1 has acquired any right title because if my lord, the first is true, my lord, the third is answered. Fourth, whether defendant number 1 has any authority to enter into possession, same, my lord, third and fourth also same. Whether registered deeds are void ab initio and is not binding upon the plaintiff. So, my lord, this should have been the first, my lord, thereafter. Whatever it is, my lord, it's there.
Yes.
Whether the plaintiff is entitled to any other such and such, my lord, these were the issues.
Punching.
Lord, kindly excuse me, my lord, it's written, my lord. Lord, 2 documents I'll place extensively, my lord, because those are the plinth of this case. One is, my lord, the joint development agreement. The other one is, my lord, the power of attorney. Exhibit A, that's the joint development agreement. My lord, kindly comes to, my lord, the judge's brief of documents. আচ্ছা প্রিন্ট হ্যাঁ ঠিক আছে এটা তো nobody is disputing this. এখন exhibit page page 1 first, my lord.
Yeah, exhibit A,
my lord.
Yes.
Lord, the agreement 10th of January 2006.
Yes.
Kindly, my lord, straight away comes to clause 1.6. Owner's allocation provided shall mean the saleable. I'm sorry.
Yes, continue.
Owner's allocation shall mean the saleable space allocable to the owner in the building to be constructed in the manner hereinafter provided, but not less than 50% of the total saleable space. That's one. Kindly, my lord, thereafter come to, my lord, 5.2.
What is the developer allocation? Shall mean a space allocated
Lord,
to the developer.
Kindly also comes to clause 1.5. Saleable space shall mean the space in the building available for independent use and occupation after making due provision for common facilities. My lord, usually, Lord, this is the usual 1.1. Kindly, my lord, turns over to page 5. Kindly, my lord, comes to page clause number 1.11. May I place it, please?
Yes.
Transfer with its grammatical variations shall include a transfer by possession and by any other means adopted for effecting what is understood as a transfer of space in a multi-storied building to purchase thereof, although the same may not amount to a transfer in law. Transferee shall mean a person to whom any space and building has been transferred. So, my lord, the first allegation that a residential portion has been converted into commercial, the parties understood it as a transfer as a whole, no restriction on the usage of the particular premises. Now, my lord, kindly come to 5.2. Kindly straight away comes to 5.2. page 12, my lord. The developer or its nominee or nominees or the transferees of owner and the developer shall be entitled to take inspection of the original title deeds. The owner shall make out a marketable title in respect of the said premises free from such and such. The deed or deeds of conveyances shall be executed in favor of the developer or its nominees in such part or parts as the developer shall require. So, my lord, these were the modalities of how transfer is to be made. So, my lord, here again, why I showed this is only to indicate, my lord, developer was entitled to nominate and, my lord, thereafter transfer. So that it was known to them. Kindly, my lord, comes to 6.51. The developer shall put the owner in possession of the owner's allocation in the building to be constructed not later than such and such by the Kolkata building plan by such and such. This was given a go by because there was some difficulty in obtaining the building sanction plan. So that this time period was relaxed between the parties, and there is no allegation also in the plaint in that scenario. The developer shall be eligible to enter into necessary agreement or agreements in respect of the developer's allocation, but shall not under any circumstances be eligible to hand over possession or any developer without first delivering the owner's allocation in the said newly constructed built-up spaces. Now, my lord, kindly turns to 7.4. In consideration of the developer having constructed the building at its own cost and made over possession of the developer's allocation to the owner, the developer shall be entitled to the remaining 50% of the total saleable space in the said building as demarcated in the map attached, consisting of the remaining 50% of the super built up area in the building excluding common parts and such to the 7.2 above. 7.6. The owner shall be entitled to sell or transfer or otherwise deal with the owner's allocation without interference, obstruction of the developer for the purpose of such and such. Similarly, 70. Similarly, the developer shall be entitled to sell or transfer or otherwise deal with the developer's allocation without interference or obstruction from the owner, for which purpose the developer shall be entitled to enter into agreements and arrangements in the name of the owner, for which no further consent of the owner shall be required.
Yes.
And those presents by itself shall be consent of the owner in that regard.
Yes.
The developer, however, shall not part with possession of developer till such time the owners are given possession of the owner's allocation. So, my lord, it was understood.
What is the number? This similarly
7.6. Page 17. This is 7.6.
7.6B.
A and B.
Okay.
7.6 B.
A and
Okay. Okay. Yes.
Now, my lord, kindly comes to 7.9. The developer shall similarly have absolute right, title, ownership, and exclusive possession over the balance 50% of the roof terrace of the proposed building to be constructed with separate entrance and willing to demarcate the developer's portion of roof terrace. So, my lord, this is my the clause from where the developer derives right to deal with the property. And the consent which has been harped on in the plaint, the consent I have read out for your lordship, my lord, the signature in the deed itself will be the consent. No further consent required. Now, my lord, kindly comes to 9.3. Acha, 9.1. Page 21, my lord.
Yeah.
9.1. The developer shall pay to the owner a sum of rupees 30 lakhs as refundable deposit to be held by the owner on account of purposes of this development. Out of the said rupees 30 lakhs, a sum of rupees 20 lakhs shall be paid at the time of execution. Such and such shall be paid upon certificate of clearance.
The developer shall pay to the owner 30 lakhs as
Security.
refundable.
This is basically a security deposit at the time of agreement. This is 9.1. Lord, security deposit 20 lakhs at the time of and thereafter, Lord. In consideration of the developer, 9.2, Lord. In consideration of the developer having agreed to build, erect and complete the said building and to make available the owner's allocation, the developer shall be entitled to be the sole owner in respect of the developer's allocation and also to have an undivided proportionate share or interest in the land comprised such and such. The said 9.3, Lord. The said undivided proportionate share or interest in the land attributable to the developer's share shall be transferred in favor of the developer or its nominee or nominees, and for the purpose of the same the cost charges such and such incurred for completion of the owner's allocation shall be the consideration for sale and transfer of the said undivided proportionate share and in the land comprised in the said premises in favor of the developer of its nominee such and such which attributable to the developer's allocation. The said consideration amount shall be apportioned in various areas of conveyances. Deeds, I'm sorry, not
various
deeds of conveyances. It is deeds of conveyance and conveyances to be executed by the owner in favor of the developer or its nominee or nominees at the cost of such and such. Now, my lord, with eyes wide open, I sign on these, my lord, clauses, these stipulations.
Yes.
And today, for some unknown reason, I come up and say, you don't have a sellable right. Not whether that is permissible under the law. Now, my lord, kindly comes to the, Lord, only one type. Lord, grants me 1 minute time, Lord. I'm sorry, my lord, I should have shown this earlier. Lord, kindly comes back to page 8, clause 4.1. Admittedly, the owner does not stay here. He has a property, he or she has a property. Now, my lord, she wants to develop the property. Now, how will she do that without the help of a power of attorney being executed in favor of developer or nominated by developer? Kindly comes to 4.1. The owner hereby grants exclusive right to the developer to build upon and commercially exploit. Kindly marks these words. Today, my lord, there is much agitation on the word commerce. Commercially exploit the said premises by constructing a building thereon consisting of 5-storied such and such by KMC. As soon as reasonably feasible, the developer shall on behalf of the owner apply to the appropriate government or authority such and such, not for doing those acts. The owner shall at the cost of the developer from time to time submit the building plan, other those permissions and clearances will be required. So, Lord, I enter into a contract, I invest my hard-earned money for some purpose. That purpose is I'll construct, I'll give you your portion, and from the rest portion, I'll, my lord, earn. Now, my lord, kindly turns over. The owner shall, 4.4. The owner shall from time to time submit all further plans, applications and other documents, papers, and do further acts and titles, such as all those permissions again. 4.5 is also the same. And 4.6, the owner shall approve with or without modification the plans as prepared by your submission. Earmarked, those things are there.
Yes, next.
4.7, immediately after the owners handing over possession of the existing premises to the developer, the portion in her occupation delivery full vacant possession and Lord, demolition will commence. So Lord, this is the basis of 7.6 which I showed to your lordship, which forms the reason why power of attorney was required and executed also. Now my lord, kindly comes to the power of attorney at page 38. Lord, I'm told, my lord,
Yes,
45
next
a
matter,
matter is
please.
fixed, my lord.
Come tomorrow.
Next day, my lord, I'll.
Next document.
Day after tomorrow. Then counsel for the defendant number 2 and 3. 2 and 3.
Lord, 2, only 2.
Defendant number 2 has argued the matter at length, but due to proceeded matter could not be completed and hearing argument could not be completed. This is the matter. And it is found that the matter is already fixed on 1st of July 2026 at 3 p.m. Let the matter appear on 1st of July at 3 p.m.
Pleasure.
Made it very clear, my lord, to my lord.
No settlement.
No settlement. I went there personally. Right, but we cannot, my lord. He's 80 years old, my lord. He cannot. Whatever is the decision, it's 87. Started from when he was 83, now it's 87. My lord, Lordship has heard me extensively. Dispute regarding publishing agreement, two publishing agreement. Dispute regarding two publishing agreement or two books. So far as book number 1 is concerned, strike, copyright will belong to the widely copyright holder. So far as second book, no problem, it belongs to the author. COVID intervened, co-publishing agreement for 3 years. It has expired by efflux of time with Kathao Kahini. Annexure A, a document is referred to with my signature, that after expiry, it's a right given to me to take a decision, either to continue or not to continue. I have taken a decision, good, bad. My learned friend's case is Miller. There is one other Miller document that is not referred to in the Katha Kahini agreement that I should give him Miller 1 year notice. That is not referred to in that agreement. And also in City Civil Court Miller, this is also not. And in City Civil Court, who are the defendant, I have made the plaintiff say, because as per his case in City Civil Court, they are the owner of the copyright, and this document he has not relied on. So suppression was argued. But my argument is that you are relying on an agreement, that co-publishing agreement. It refers to Annexure A. Annexure A, Miller, doesn't refer to this letter, but this letter. So this is the relevant document. And Miller, he says there is no termination. I have shown Miller there is a termination. If the termination is wrongful, claim lies in damages. And second argument was there is no novation, no novation, agreement has come to an end. And in copyright law, I had shown 19 subsection 5, is no period is prescribed, the agreement is for 5 years. Those agreements of 2005, he has continued, but I have terminated, like a license he was continuing. If no term is there, after 1994, it's 5 years. That's the law I have Millard cited. See, Millard, so far as Millard, prima facie case, I am the owner of copyright. My first son is on record. Second son doesn't want to come. He stays in US. He, Millard, was not made a party in City Civil Court. I have not made a party. They also have not made him the party. So for the judgments, Millard, I'll only distinguish his judgment and Millard take my seat. And I've also cited judgments that if I have terminated the agreement, it's an infringement. You cannot continue. And Miller, wrongful termination, the claim only lies for damages. I have shown judgments that if a termination is wrongful, I have to give him 3 months notice. I am not giving him 3 months notice. He has a claim for damages for 3 months. I have Rajasthan Bureau has said so. These are all division bench judgments. Now, let us take his first judgment. Chitra Singh was the Jagjit Singh case. Chitra Singh versus Panch Media and others. 2016 SCC Online Bombay 2364. Lordship found out. Now, Millard, most important,
If your lordship takes me lord, it's a personality rights. Now my lord, copyright lordship is after long. I have not found lordship in that determination. A new right has come, is a personality rights. Right, my lord, Amir Khan or the mega star here, my lord, Prasenji. You cannot use his, my lord, likeness or his pictures, my lord. All, my lord, on the, my lord, hotels, etc. without. So this is a case of personality rights. Kindly have a look at it. Para 3. If your lordship has a look at para 3. In reply, it is submitted that the defendant number 1, the defendant is engaged in ongoing live concert of leading assets, whereas the defendant number 2 is one of the biggest online movie and event ticket brands. So the defendant number 2 is a leading auditorium in the city of Mumbai, which promotes fine arts and provides the platform to the artist showcase. It is submitted that the deceased singer Jagjit Singh enrolled himself as a member of Indian Performing Rights Society (IPRS), which is the representative body of the owner of the copyright music, composers, lyricists, public music. It is submitted that the society is the owner of the copyrights of the work Jagjit Singh has granted license to use the said work. So Lordship knows under section 33 of the Copyright Act, there is a copyright society. Under the copyright society, Millard, rights are given, Millard, by the authors to administer the rights, and admittedly Jagjit Singh being a member has got a right. So Millard, that is Millard, an admitted position that copyright Jagjit Singh's right in the copyright society is Millard given to the society itself. Now Lordship correct. It is the case of the defendant that the defendant has duly procured a license from the society on payment of a license fee for using for some of the musical works of Jagjit Singh for the concert to be held on 18th February 2016. The defendant has produced various documents, including printouts from IPRS as well as relevant page showing membership of the deceased singer of IPRS. So he had a license. Millard may not be from Jagjit Singh's wife, but from Millard IPRS, where Jagjit Singh was a member. The license granted by IPRS to defendant number 1 for making use of the musical work of the deceased singer and various other license obtained by the deceased for performance to be held on 18 February 2016. Based on this document, it is submitted defendant has the authority to make use of the musical work of the deceased singer and has accordingly proposed upcoming concerts for the fans of the deceased singer. Though the case of main is named a breach of copyright, there are other bundle of rights. So the person, the licensee in concern, has a license from anywhere. He may not have from the author, but he has from the copyright society of where the author is the member. Unlike the present case, one should have a right flowing from someone. The author is before the court. He is saying that I have not given him the right in the present case. But in this case, there was a right given by the Copyright Society IPRS. This is a statutory license under section 33. He was holding it. Now, Millard, kindly have a look at it. Millard, kindly take paragraph 9. Coming to the facts of the present case, a part cause of action pleaded in the court is a breach of copyright, so the other rights are simply categorized, and any concerned rights. The other cause of action is based on defamation, damage, name, reputation, goodwill of the deceased celebrity. From both these cause of action, defendant have a complete answer, at least at the prima facie stage. The defendant has duly acquired a license to use the musical work of the singer on payment of a price. So from the society. The defendant have produced material in support of the acquisition. The material prima facie is believable and acceptable. On the material, it is certainly cannot be said the defendant are making unauthorized use of the musical work of the late singer. As for the case of defamation and damage and reputation and goodwill, there is hardly any material placed by the plaintiff before the court. 7 except a bare assertion, no prima facie case is made out either in the copyright infringement or of defamation. Because of that, he any event has a license from the society registered under the Act under section 33, which defendant was the member, unlike the present case. So you have a license. Now, as far as the personally right is concerned, there is no pleading, etc., etc. Now, kindly straight away come to the balance of convenience part. That is paragraph number 11. Coming to the balance of convenience, it is not in the interest of justice to restrain the defendant at this stage either from holding the concert or for displaying or announcing the name of Jagjit Singh in concert therewith. After obtaining a license to make use of the licensed work of the late singer, the defendant have procured the license and thereafter announced the show and sold tickets. The performance is likely to be held today evening. So injunction is beyond. What is the balance of convenience? The suit is moved in the morning for an injunction when the show is to be held in the evening. It will be complete loss of face, entailing irreparable prejudice apart from monetary loss if the concert were to now be cancelled or the defendants were to be restrained from making use of the name of the singer. On the other hand, even if the plaintiff's right in an assertion of the right and the case of infringement of a right, the plaintiff can certainly be compensated in monetary terms. So despite, because the show was on the evening, the suit is moved in the morning and an injunction is sought for. So, my lord, despite section 55 of the Copyright Act providing that damages is in addition to of injunction and specific performance, court is refusing to grant an injunction. My lord, with this judgment test our case. There is an agreement of 2000-2001, written agreement between the parties. If it is an only thing is recognized under the Copyright Act is an assignment, section 19. Because copyright is a bundle of rights. If you assign, you can assign your bub. So no term 5 years, 2006, 2007, automatic ends. They are continuing permissive user. In the meantime, there is an agreement, co-publishing agreement, which says the user for 3 years, that 3 years have come to an end. For adequate precaution, I have given a termination notice. I have argued that. Now, kindly takes the next judgment of my learned friend, which is your lordship must be having it.
What is the suit?
Suit for injunction of copyright on termination. Infringement, because on termination it's an infringement. I am cited judgment, I am not touching it because lordship told my junior on the very last date only distinction of the judgment.
Yes.
Nothing more, nothing less. Where is the authority to publish? It's not like Jagjit Singh case that IPRS has given the defendant a permission. I am coming to court, I am said that I have withheld the permission. I have taken away the permission.
Yes.
Now kindly have a look at 2018 volume 16 SCC 117 cited by my learned friend.
2018?
Pirosmar Corporation versus MGR Steel Private Limited.
Without a license.
Have lordship found out or agreed?
Yes.
Kindly says it is on infrastructure law and maritime law. The only judgment on this aspect of copyright is which is cited is the case of Jagjit Singh. Now, kindly take away, straight away, take the act, take copyright. Only the Copyright Act. আমি তো মেরিটাইম জানি না দেখছিস তো ভুলভাল অ্যারেস্ট করে নিয়েছি তো
কপিরাইট নেই
kindly have a look at just below 2 paragraphs on this. This is his branch, that I also know this is his branch. I do not know anything on that.
That why he has searched this.
Yes. Kindly have a look at internal page, lordship will see, page 28, is written at the top. 2828.
Page 28?
28 of this judgment, Judgments, page number are at top in the SC.
Print page. 28.
Kindly, have a look at paragraph 34, 32 and 63 are quoted on effect of novation, recession and alteration of the contract.
Page 28.
Page 28, 2828. Its paragraph starts with paragraph 34, 3434. Has lordship found out?
No.
May I just check,
Inner page 44. Might be some changes.
149.
এটা কি দিয়েছিস?
ঠিকই তো দিয়েছি। ঠিকই তো দিয়েছি। পেজ 149 টা দেখাবে তোকে।
পেজ 149?
হ্যাঁ।
আমারটা মিলছে।
Internal page 28.
Oh, internal page 28. I'm correct.
ঠিক ঠিক তো।
হ্যাঁ, ঠিক আছে।
It is yours.
It's my learned friend, not me. Yes.
34.
Kindly Miller, take Miller 149. Just step in.
Page?
Miller, page 149, paragraph 34. Has Lordship now found
Yes,
out?
149.
If your Lordship finds out, Miller, page 62 and section 62 and 63.
Yes. 62, 63.
Yes.
Contract Act.
Yes.
Effect of novation.
Novation, recession, and alteration of contract. This is
Correct.
cited by my learned friend.
Yes.
If the parties to the original contract agree to substitute a new contract for it, or to rescind or alter it, the original contract need not be performed. So, will section 62 takes into effect three things: substitution,
New
recession,
contract.
and novation.
No.
Of three scenarios.
Substitution and new contract.
Yes. This is Miller, he says.
Resign, alter, or original contract.
Why this is came, Miller? I said, Miller, in the course of argument, Miller, the old contracts to innovated because parties have now signed or replaced or substituted. He says these are contradictory. If you say one, you cannot basically say the other. But Miller, the section, Miller, takes threefold together. Now, Miller, kindly, Miller, takes the next, Miller, para 38. Para 38. Lordship has found out para 38. Kindly take, Miller, the quotation from the Supreme Court. In the present case, the modifications do not go to the root of the first contract and do not change the essential character. The facts do not warrant inference of the parties intended to rescind the contract dated such and such. The arrangement was entered into in response to the present demands for delivery under the contract with a view to implement it. The arrangement has no independent contractual force, no meaning, and thereby separately and independently from the original contract. This is the case. So here, Willard, there is a co-publishing agreement with my consent. My letter is there. Willard, in the intervening period, he is not going to publish, but someone else is going to publish. And I have consented to it. And my consent is on certain terms. That Willard, after expiry, Willard, I am entitled to take a decision as per clause 3 of the agreement.
Still they are publishing.
They're still there publishing, unless the injunction, Willard, where is the question? Still they're publishing. It's an admitted fact.
You are getting royalty.
No, I am not getting any fact. That is what, Willard, we were sent to mediation. I am not getting a single farthing. The suit is of 2023. We are in 2017. And they have started publishing. I don't want to go to the facts with a correction, additional chapter and correction of errors. I have not consented to it. If that is not an infringement, this is obviously an infringement because author has a moral right. Without his consent, this cannot be done. I'm not getting a license. If something is continuing, kindly Willard appreciates. If something is continuing, I must get in lieu of the performance of the agreement. Now, Willard, kindly take paragraph 14, we just quoted. In the present case, Willard, kindly take Willard the next part, 15. The modifications are read into and become part and parcel of the original contract. The original terms also continue to be part of the contract and are not rescinded, superseded, except insofar as they're inconsistent with the modification. Willard, I agree to it, Willard. Inconsistent with modification is, Willard, my right to take a decision under the contract. Now, Willard, kindly take. Those original terms cannot make sense. Read with alteration must be rejected. In my view, arbitration clause in case is no way with the alterations or is no way inconsistent with subsequent modification of the contract. Naturally, Willard, an arbitration clause, Willard, survives, Willard, irrespective of termination of the main contract. So, where is how in the facts it is applied? Two parties come forward, execute an agreement with the consent of the owner. Consent is recorded in writing, giving a owner the right to take a decision. If this is not altering the very root of the contract, what is alteration? The owner has taken a decision. Now, Willard, kindly takes Willard 39. We approve the said judgment, laying down the correct law on the expression alter in section 62 of the Contract Act. In order that a contract is altered in its material particulars fall under section 62, it must be clear that the alteration goes to the very root of the original contract and change the essential character so as to modify the contract must be as doing away with the original contract. If the modified contract has no independent contractual force, in the present case it has, There's a co-publishing agreement. It has no meaning for this meaning from this separately. Independently from the original contract, it is clear that there is no new contract which comes into the original terms continue to be part of the modified contract, except to the extent that inconsistent with the modified contract. So when I place reliance on it, it is inconsistent with the modified contract, which gives me a right to take a decision. I have taken a decision, I am before this court. Now straight away Lordship will come to the next judgment cited by my learned friend. Yes, is the case Miller 2011 7 SCC page 69. Case of Amar Singh versus Union of India.
Yes.
The case this is a famous case in relation to tapping of the telephone and a right of privacy. In Miller, the said case, the Supreme Court goes on to say what is suppression and what is the effect of suppression. Now, Miller, kindly have a look at paragraph. Miller, what was the suppression there? Kindly have a look at paragraph 44, page 85. Has Lordship found? In this case, very strange thing has happened. At the time of filing of the writ petitioner, the petitioner implicated Indian National Congress as respondent number 7 and also made direct allegation in paragraph 2(1) and 2(10) such and such. In paragraph 5 of the writ petition, there are indirect reference to the respondent. In various grounds taken in support of the petition, allegations have been specifically made against the 7 respondents, even though in the order of the court dated such and such, there is the observation that the respondent number 7 has been implicated unnecessarily. The said respondent has not been deleted, then amended constantly. Also, the respondent number 7 remains implicated. The averment against the respondents were not withdrawn by the petitioner. In the month of February 2011, towards closing of the hearing, an additional affidavit which makes very interesting reading was filed by the petitioner. All 3 paragraphs of the affidavits are set out here in that. I, Amar Singh, kindly take below paragraph number 3 of that affidavit in question. It is stated that the petitioner was the complainant in the instant case. It is stated that the petitioner is satisfied with the investigation of the of Delhi police and therefore withdraws all averments and contention and allegation made against the respondent number 7. So this is a specific stand on the affidavit which was sought to be suppressed. Now, Millard, kindly take Millard paragraph. Millard, kindly take the next page. Millard, page 86, Placitum A. Subsequent affidavit also acknowledges the petitioner is satisfied with the investigation of the Delhi police in connection with the forgery to have been committed, namely fabrication of the orders on the basis of the telephone lines of the petitioners were trapped. The petitioner also makes statements that Anurag Singh edited and tampered some of the conversion of the petition. Now, Millard, kindly take 49. In 2006, the gravamen of the petitioner's grievances against the respondent number 7, the basis of the petitioner was the information is derived from Anurag Singh. On basis of such petition, he invoked the jurisdiction of this court and an interim order was issued in his favor, which is still continuing. Now, when the matter has come up for contested hearing, he suddenly withdraws his allegation to the respondent number 7 and feels satisfied with the investigation of the police in connection with the aforesaid case of forgery and also with the same Anurag Singh edited and tampered certain conversation of the petition. Now, para 50. The court wants to make it clear. An action of law is not game of chess. A litigant who comes to court invokes writ jurisdiction must come with clean hand. He cannot perseverate and take inconsistent positions. Apart from the aforesaid, the writ petition which has been filed on 21/1/2006, there is no mention of the fact the petitioner gave a statement under 161 of the Code of Criminal Procedure in connection with the investigation of the FIR lodged on such and such. From records of the case, it appears that the petitioners gave section 1 of this section 161 statement on such and such. In the writ petition, there is a complete suppression of the aforesaid fact. How, Millard, it's matching with my case? A statement under section 1, sir, is certainly a material fact in the police investigation connection with FIR. The investigation is to find out genuineness of the documents on the basis of which the writ petition was moved. In the factual total suppression in the writ petition of the fact the petitioner gave a statement under 161, or in that investigation is in our judgment suppression of a material fact. It is therefore clear that the writ petition is frivolous, speculative in character. The court is of the opinion that the so-called legal question on trapping of telephone cord cannot be gone into on the basis of the petition, which is so weak in its foundation. This is the case here, the suppression of a proceedings in court. Now, my lord, 53 onwards, there are, my lord, what is suppression? India is a land of saint, and, my lord, other things. Why? This is basically on relying on an ex parte order. Kindly, my lord, take para 54. I had moved it on notice. In such and such, through such and such, it's the duty of the party asking for an injunction to bring under the notice all material facts for determining the rights of injunction. It is to the excuse, it is no excuse for him that he was not aware of the importance of the fact which he omitted to bring forward. A plaintiff, while applying ex parte, comes as far as it is expressed under the contract with court that he will state the whole facts fully and fairly to the court. If he fails to do so, the court finds that when the other party applies to resolve the injunction, then any material fact has been suppressed and not properly brought to the court. The plaintiff is told the court will not decide on merits, and he has broken the faith of the court, and the injunction must go. Here I am not enjoying an injunction on an ex parte stage or on the contested hearing on the ad interim stage when full facts were not brought. The full facts have been brought by the party, and lordship will see. Now, my lord, kindly takes, my lord, the next judgment in question.
Yes.
2012-6 Supreme Court cases 792.
Yes.
Bestsellers versus Aditya Birla Nuvu.
Yes.
This is in relation to a franchisee. What is the basis of the case? That the owner of a property was injuncted from leasing out his property. In that suit, my lord, there was a quantified claiming damages and claiming money. My lord, the Supreme Court said, my lord, that look, since you have quantified your entire claiming damages and money, that is your adequate relief, and this is one of the ground for refusal of injunction under section 41. My lord, unlike the provision of the copyright, in addition to, not in derogation therewith. Kindly have a look at, my lord, paragraph 7 or paragraph 5. Para 5. Page number
7.
Yes. Para 5, lordship takes, my lord.
Yes.
7 will also do. My lord, Liberty Agencies, however, sent a letter dated 26th of February 2010 claiming a constitution of a partnership firm has changed and its partner A.C. Thirumaraj had retired, and A.C. Thirumaraj, as the owner of the scheduled property, has terminated the tenancy of the suit property in favor of Liberty Agencies and initiated a collusive eviction proceedings with an intention to defeat the claim of the respondent number 1. Now, my lord, 7. Along with the suit, the respondent number 1 filed an application under Order 39, Rule 1 and 2. What is the injunction? Praying for a temporary injunction restraining defendants from leasing, subleasing, alienating, encumbering, or scheduled property in any way or manner pending disposal of the suit. Liberty Agencies and A.G. Thirumaraj filed an objection to the application of temporary and stated inter alia that the objection of possession of the suit property has been delivered to Bestsellers Retail Private Limited. The additional civil judge heard the parties and by an order dated allowed the application for injunction and restrained Liberty Agencies and partners A.C. Thirumaraj from leasing and subleasing and alienating or encumbering the scheduled property in any manner pending the disposal of the suit. Aggrieved, A.C. Thirumaraj filed a miscellaneous appeal under such and such against the order of injunction. It was brought to the notice of the High Court that in spite of temporary injunction granted in favor of the respondent A.C. Thirumaraj, Bestsellers were operating a shop of scheduled property in name of Jack and Jones, and by an order dated 6/7/2010, the High Court restrained Bestsellers from carrying out business into scheduled property until the orders of the High Court High Courts and for vacating of the interim order. By the impugned judgment, however, dismissed the miscellaneous appeal and rejected the appeal and vacating the interim, but directed the respondent given undertaking trial court in case the respondent fails, it will compensate loss to S.H. Lumaraj for the bestseller such and such. Now the question, kindly take Millard, prima facie case balance. Now Millard, kindly take Millard, para 13. The learned counsel submitted, the respondent number 1 itself has claimed damages to the tune of rupees 20 lakhs and odd as an alternative relief in the event the suit for specific performance of the contract is not decreed. They argued as the plaintiff itself has made a claim for damages for alleged breach of agreement by the defendant, the court should not have granted temporary injunction in their favor. Millard, 14 is most important. The learned counsel for the appellant further submit that section 14(1) of the Specific Relief Act provides clause B that a contract which runs into numerous details or which is so dependent on personal quantification or volition of the party or otherwise in nature of such, the court cannot enforce specific performance of material term, contract cannot be specifically performed. They submit similarly 14(1) provides that a contract performance involves a performance of continuous, the court cannot supervise. They submit the agreement between liberty agencies is a contract of agency covered under clauses B and D of 14(1) of the Specific Relief Act, and it is one which cannot be specifically enforced. Now kindly straight away comes to the finding of the court, which Lordship will find from paragraph 33. Despite the claim of damages made by the respondent number 1 in the claim, the trial court has held that if temporary injunction is sought for not granted, liberty agencies may lease or lease the suit scheduled property or create third-party interest over the same, and in such event there will be multiplicity of proceedings and thereby the respondent number 1 will be put to hardship and mental agony. Which cannot be compensated in terms of money. The respondent number 1 is a limited company carrying on business. We fail to appreciate loss and agony. Now 34. The High Court has similarly held that the impugned judgment, if claimed, would the claim would be frustrated. Therefore, it is proper to grant, and the trial court rightly granted an injunction to the partner. High Court lost sight of the fact that if temporary injunction restraining liberty agency and partners from allowing and leasing out subleasing income as scheduled property were not granted, ultimately the suit would be entitled to damages and proved by the court, in the other words, did not suffer irreparable injury. So it's a case of the injunction on the owner's property being refused. Here the owner is asking an injunction on his property, his copyrighted books. Because the book says, Millard, the copyright belongs to the owner and is reserved by the owner. Now, Millard, the next judgment.
Whether that cannot be a final order in view of the interim order, if any pass.
Millard, any trademark suit, injunction, Millard, is passed, is Millard like a final nature, because the final nature is a perpetual injunction. Any trademark suit, any copyright suit, any design suit. And Millard, that is the reason Lordship asked me on the first date. I had cited 3 division bench. I'm not repeating. In the interim stage, ex parte stage, ad interim stage, Bombay, Calcutta, and Millard, Delhi, I have already cited. These are all interim. I have not cited a single judgment on final hearing.
Yes.
7 except in between the part, 7 except in respect of Millard this agreement. And what is the agreement? It's a mere license. Justice Gupta's judgment sitting in division bench. When he construed this agreement, that termination clause is not necessary to terminate the agreement.
Okay.
Now, Millard, next Millard is 2010. That is all, Millard. If your Lordship takes, Millard, any trademark suit, the final relief is perpetual injunction and damages. In the first day when, Millard, I am moving before your Lordship or my learned friend is moving, Millard, it's nothing, Millard, but, Millard, injunction in aid of the suit. We all, Millard, move it ex parte. Ex parte injunction is a matter of rule, Millard. No, because that is provided in the act itself.
Correct. But here there is an agreement and dispute with regard to this agreement.
Yes, correct. So, Millard,
there is a dispute with regard to the agreement, whether that dispute can be decided during
kindly have a look. Kindly have a look at section 55. Kindly have a look. If Lordship has a copy. Because it cannot be a position, my lord, the suit will remain and he'll go on publishing and I'll not get any royalty. Lordship has to balance it. Can it be a position? My lord, that my lord, he says the agreement is continuing. He is continuing and I am not getting money. My lord, I am to get a money under the agreement.
No, that is not your case that you are not getting money is not paid.
Absolutely. I, my lord, immediately came to court. I did not come to court. He has filed proceedings in court, in city civil court. I did not come to court. It is who he went to city civil court and said the agreements are continuing and failed to get an order there.
Yes.
Kindly, my lord, kindly have
So
a look at
why you are not filing an application before the cities?
commercial dispute has to be filed here, my lord.
So what is the dispute before the cities?
My lord, they have filed a suit, termed is the declaration and injunction has filed it there.
With regard to the same.
Challenging the termination. This is a complete, my lord, this is a complete copyright infringement suit, my lord, covered under with the Commercial Courts Act.
Yes.
I have filed it here. City Civil Court at that point of time did not have a commercial jurisdiction there. Kindly have a look at, my lord, where a copyright in the
Which provision you are dealing with?
55.
55 of?
Kindly take 51 first.
Yes.
When copyright is infringed. 51. A copyright in the work shall be deemed to be infringed. So deeming provision. If any person without license granted by the owner of a copyright, I am the owner of the copyright, or the registrar of copyrights under the Act, or in contravention with the condition of license so granted, or any condition imposed by a competent authority, does anything exclusive to do under the Act is conferred upon the owner. To permits any place of profit to be used, communication of the work to the public, such communication constitutes an infringement of copyright, unless he was not aware that he has no reasonable ground of believing that such communication to the public to be an infringement of copyright. So, my lord, it's a deeming provision. Without license, if anyone does, there is an infringement on the face of it. It's a deeming provision. I am coming under the Act.
No, deeming provision is correct.
Correct.
But you had an agreement.
Will agreement? Bound up, it has
Subsequent.
come to an end.
That's why you are telling that it's come to hand.
I do not say agreement says so.
Okay, agreement.
For 3 years. After 3 years, he is publishing. I have come back to court. He is falling back and saying there are 2 agreements.
Correct.
Of 2020, 2001 and 2002, which are the agreement in his favor. Now, agreement doesn't have any term. So, what is the effect in law? 1905 Lordship takes 1905. It's after 1994. It's a license. Its highest grade can be of an assignment. If it is an assignment, if your Lordship kindly takes Willard, that's the highest he can get. He cannot get more than, because nothing, there cannot be a copyright without the Act. Kindly take 1905. 1901. No assignment of copyright in any work shall be valid unless it is writing and signed by the assigner or duly authorized agent. So 1901. Now, Miller, 1905. If the period of assignment is not stated, it shall be deemed to be 5 years from the date of assignment, and this is in respect of the agreement after 1994. There should be a right to prevent an injunction in law, because there cannot be any copyright otherwise than the Act. It doesn't recognize license.
Okay.
Kindly take 55 now. Well, I am just responding to the judgments. Otherwise, I have argued on the merits and I have given a Lordship's query. I have answered by 3 judgments. In the interim stage, Millard, in an interim stage, whether this can be granted or ad interim.
That's the question.
Yes, I have given Miller 3 judgments, Miller. I do not want to repeat there.
Okay. Next.
And 38 is license. Kindly 30 capital A. Kindly have a look at it. Lordship asked me. I have only Miller pointed out the section. Kindly have a look at 30 capital A.
Yes.
For the purpose of license also, kindly have a look at it. Licenses of the owners by the copyright. Lordship has found two concepts, assignment and license. Owner of the copyright in any existing work or the prospective owner of the copyright in any future work may grant an interest in the right by a license in writing by him or his duly authorized agent. So it's provided in case of license relating to copyright if you will not. Now you are 30 capital A. It has come into effect in 1995. The provisions of section 19 shall with necessary adaptation and modification apply in relation to license under section 30 as they apply in relation to assignment of copyright. So 5 years. So that is 5 years plus 5 years. He has continued. I have never stopped him. And this is 3 years. So where is if it is a license, 5 years. If it's the assignment, it's 5 years. I am not citing. So there should be a subsisting right. Thereafter, I have not executed the agreement or any right in his favor. If he falls back on his old documents, Millard, under the Act, it's 5 years. He has printed and continued till 2019. I have not stopped it.
Okay.
So this is Millard. Kindly have a look at 55, Millard. If your Lordship has asked me the question, Millard, 55 is also the answer. Civil remedies for infringement. I could not have gone, Millard. Now City Civil Code has a Millard commercial division. They are taking record from this year or last year. But that time, Millard, it was not there. Tumi gacho. And I've also paid an inquiry for damages. That is the trademark suit we all do. We don't make it a money claim. We make it. That's the form. Civil remedies for infringement of copyright. Where a copyright in any work has been infringed, the owner of the copyright, except as otherwise provided by the Work Act, will be entitled to all such remedies by way of injunction, damages, accounts, and otherwise that are conferred or may be conferred by law for infringement of a right.
Yes.
And whatever he is selling, that is also infringing copy, section 58. Kindly have a look at it. I am the owner. So far as the infringing copies, also I am the owner. That's the Act. That's the why injunction is there. Because I am getting injunction on my property. That's the Act 58. Right of the owner against a person possessing or dealing with infringing copies. I am the owner. All infringing copies of any work in which copyright subsists and all pages used or intended to be used for production of such infringing copies shall be deemed to be the property of the owner of the copyright, who accordingly may take proceedings for recovery of possession thereof or in respect of conversion thereof. Yes. Provided the owner of the copyright shall not be entitled to any remedy in respect of conversion or infringement if the opponent proves that he was not aware and had no reasonable ground to believe that the copyright subsisted in the work. This is not the case. Of which the copies were alleged to be infringing copy, that he has reasonable grounds for believing that the copies or plates do not involve infringement of copyright in the work. That is not the case. So that in these facts, Millard, this is whatever Millard way Lordship decides, Millard, my client is Millard. Because he cannot go with the litigation anymore.
Yes. That's all.
That's all. We have filed the notes. If your Lordship wants a written notes, I can give it.
File the written notes they have filed, no?
I think Millard. Very well, Lordship. Gives me time, Millard.
Both party filed.
No, we have to.
I don't think any party has filed.
One file. Respond number 1 and 2. Who filed?
Respond number 1 and 2. Very well, we'll file it, Millard. I am not saying.
Respond number 1 and 2 have filed. That is your client.
I think, but we might.
But we'll file. We'll file it, Millard. Give us
some time back.
Very well.
Hearing concluded. Full list of counsel for the parties are directed to file their written notes of argument within a week.
Within a week, Millard.
Let the matter appear on 7th July under the heading to be mentioned for filing written notes of argument.
Week's time. He has suffered for so many years, 2 weeks will not make it.
Within 2 weeks,
The horse is always suffering.
fixed on
Yes, I suffered.
13 July.
We come from down to a
13
society,
July,
we suffer.
under the heading to be mentioned, filing written notes about.
Next matter, my lord. After we file the notes, your lordship requires any clarification, lordship will put it. Because some time has lapsed, my lord, since the last hearing. There has been a time lapse. Your lordship will see the notes if there are any clarifications required, my lord, because.
My lord, the very next matter, my lord, state was not appearing for the last 2 or 3 occasions. It's appeared today. They would want a copy of the writ petition, which we benevolently want to supply them with. If your lordship kindly permits us to do so, they can come back within 2 days.
Lordship, I am appearing for the
What is the matter?
The matter is regarding, my lord, certificate granted under the West Bengal Apartment Ownership Act. Without hearing, my lord, the parties, I am a person interested. I have an interest in the roof. I hold a registered instrument regarding which there are civil suits pending. Despite that, my lord, dehorse me, my lord, it appears that in respect of the remaining portion of the building, a certificate has been granted under the Apartment Ownership Act.
To whom?
In favor of a purported association in which roof has been declared to be a common area, despite the fact that the roof was dealt with in my favor by a registered.
Who is for the owner?
Owner is on notice.
I am for the state lordship that
Who is for the owner?
one innocuous
They filed Wakalatnama through one Mr. Priyanko Banerjee. He's on record. He's written to my advocate on record.
lordship only one innocuous press the lordship a copy may be served upon us and lordship 2 weeks time may be granted to us lordship.
The difficulty is they are proceeding on the basis of this and they are getting other clearances. I am running a terrible risk of getting non-suited in civil.
Who are you?
I am a person who holds a registered instrument regarding a portion of the roof of the building for the purpose of onward construction. I have a sanction plan in my favor. Despite all
You are the developer.
I am the assignee of the developer. The developer constructed up to a certain stage. That is complete. Facilities given, they are there. But in respect of the other portions, as mentioned in all the deeds also.
Who has entered into an agreement with you?
But the original developer has entered into an agreement with me. It's an assignment agreement. That assignment agreement subsequently it's a registered instrument as well.
No,
So
once he entered into a development agreement with certain floors, in that way, what about the first construction has been made with regard to 7th floor or 8th floor? Now you want
up to that floor, he has made the construction. Thereafter, roof, the construction to make over the ultimate roof is in my favor. And then on the basis of that, I am required to proceed.
You are the owner.
He's the association of persons.
Ah.
They have got a apartment ownership certificate registered. Now, in that registration, they are showing certain portions to be common, which is actually not common. And that has happened behind my back. What I'll be seeking is that everyone be heard so that the registered within the realms of the Apartment Ownership Act can make that necessary correction. He is not an adjudicator. Adjudicator is civil court. But he should not be granting a certificate like that in their favor. That's my only thing. The state has appeared after 2 or 3 notices. They are now before your lordship. If they want, I'm giving them a copy of my copy.
I'll require a lordship
I'm
a
giving them a copy. My only request is let them not take 2 weeks to revert for something with the instructions of which are available in the next bill. Registrar sits in 2 or 3 one case that I wrote, which takes even for an obese man like me, 7 minutes to walk. That's all right. There's no difficulty. We welcome him.
10 days time may be given lordship to take necessary instruction lordship.
Press for supply of copy of the writ application along with the documents as he has not received any copy of the same. Accordingly, petitioner is directed to serve the copy of the print along with the copy of the writ petition along with the document to the learned advocate appearing for the state by tomorrow.
I'm serving right here.
By tomorrow, full stop. The counsel for the state press for time to take instruction. According cases adjourned, let the matter appear on when?
Date should be 12 July lordship. Grateful.
When? 12 July.
Lordship that
you come and I will come.
Lordship,
Hear you.
I apologize lordship that I heard that lordship.
I have no problem.
Lordship, I apologize. I heard that lordship 12 July. Lordship fine fixing lordship.
With lunch, breakfast, dinner.
I apologize lordship. I heard that wrong. I heard that wrong lordship.
That to high tea, not the normal.
Sunday only normal breakfast.
Lordship, that at least 10 days time may be given, Lordship, that.
Come on, 8. Come on, 8.
8. Great.
Under the same heading.
Lord, I have handed you over the copy.
Under the same heading.
My lord, before your lordship rises, my lord.
3 p.m. then you come August.
My lord, before your lordship. My lord, before your lordship rises, my lord, with folded, and I'm mentioning one matter from the appellate side, my lord.
Huh?
I'm mentioning one matter from the appellate side, my lord. Item number 32, my lord. But I will be ousted, my lord. She was fixed to leave matter, my lord. But kindly consider it can be uploaded tomorrow, my lord, in the list. On the top, my lord. Fix, my lord.
Who will take note of your matter?
But kindly
Will
consider.
take because can be done, sir. Tell me how.
I will ousted, my lord. I have been ousted, my lord. Kindly. 32 from the appellate side.
Yeah, check here. Can.
My lord, may I have the leave to mention one appellate side matter? I'm appearing in person. My lord, may I have the leave to mention one matter? I'm appearing in person.
Which matter?
It is an appellate side matter. It's,
let's say this is not the time, sir.
I have mentioned in the morning.